Gene, are you in room 1? You ready? Okay. I'll try to remember to read slow. Yeah, I do pick up speed. I'll try. Ready? All right, let's bring the jury in.
We do, Your Honor.
Defense?
Yes, ma'am.
All right. Good morning, folks. Hope you all had a good evening. You've each been given a copy of the jury instructions that I'm going to read to you. This is your copy to keep. You will be able to take this into the jury room with you. This time around, you will be able to take your notepads in when you retire to deliberate. So if you want to make notes on these copies, feel free to do that, all right? The way I do this is I'm going to read up until 3.10 and then stop, let the attorneys do their closings, and then I'll continue with the rest of the jury instructions after the closings. I read it this way so that you will know what all of the elements of the crimes are charged and what it is that you're looking for when trying to determine a verdict. We find that's very helpful to the jurors when you're listening to closings. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Markeith Loyd, the defendant in this case, has been accused of the crimes of first-degree murder of a law enforcement officer, attempted first-degree murder of a law enforcement officer, aggravated assault, carjacking, and possession of a firearm by a felon. In this case, Markeith Loyd is accused of first-degree murder of a law enforcement officer. First-degree murder of a law enforcement officer includes the lesser crimes of first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Debra Clayton was killed by Markeith Loyd, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and is lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any lawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Markeith Loyd may be found guilty of first-degree murder of a law enforcement officer or any lesser included crime. To prove the crime of first-degree premeditated murder of a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. 1, Debra Clayton is dead. 2, the death was caused by the criminal act of Markeith Loyd. 3, there was a premeditated killing of Debra Clayton. 4, Debra Clayton was a law enforcement officer. 5, Markeith Loyd knew that Debra Clayton was a law enforcement officer. 6, Debra Clayton was engaged in the lawful performance of a legal duty. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or the state or any political subdivision thereof who is vested with the authority to bear arms and make arrest, and whose primary responsibility is the prevention and detection of crime or the enforcement of the penal, criminal, traffic, or highway laws of the state. This definition includes all certified supervisory and command personnel whose duties include, in whole or in part, the supervision, training, guidance, and management responsibilities of full-time law enforcement officers, part-time law enforcement officers, or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of a premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Markeith Loyd did not act with premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused the death, and E, Markeith Loyd was in fact so provoked and did not cool off before he committed the act that caused the death of Debra Clayton. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should find You should not find him guilty of first-degree premeditated murder of a law enforcement officer. In this case, Markeith Loyd is accused of attempted first-degree murder of a law enforcement officer. An attempted killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find there was an attempted killing of Joseph Carter by Markeith Loyd, you will then consider the circumstances surrounding the attempted killing in deciding if it was attempted felony murder or whether the attempted killing was excusable or resulted from justifiable use of deadly force. The attempted killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The attempted killing of a human being is excusable and therefore lawful under any one of the three following circumstances. One, when the attempted killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the attempted killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or three, when the attempted killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before the defendant may be found guilty of attempted first-degree murder of a law enforcement officer. To prove the crime of attempted first-degree premeditated murder of a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. 1, Markeith Loyd did some act intended to cause the death of Joseph Carter that went beyond just thinking or talking about it. 2, Markeith Loyd acted with a premeditated design to kill Joseph Carter. 3, the act would have resulted in the death of Joseph Carter except that someone prevented Markeith Loyd from killing Joseph Carter or he failed to do so. 4, Joseph Carter was a law enforcement officer. 5, Markeith Loyd knew that Joseph Carter was a law enforcement officer. 6, Joseph Carter was engaged in the lawful performance of a legal duty. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or the state or any political subdivision thereof who is vested with authority to bear arms and make arrest, and whose primary responsibility is the prevention and detection of crime or the enforcement of the penal, criminal, traffic, or highway laws of the state. This definition includes all certified supervisory and command personnel whose duties include, in whole or in part, the supervision, training, guidance, and management responsibilities of full-time law enforcement officers, part-time law enforcement officers, or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. A premeditated design to kill means there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. Aggravated assault. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. 1, Markeith Loyd intentionally and unlawfully threatened either by word or act to do violence to Antoine Thomas. At the time, Markeith Loyd appeared to have the ability to carry out the threat. 3, the act of Markeith Loyd created in the mind of Antoine Thomas a well-founded fear that violence was about to take place. 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Antoine Thomas may be found to have been in fear, and actual fear on the part of Antoine Thomas need not be shown. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. It is not necessary for the state to prove that the defendant had an intent to kill. To prove the crime of carjacking, the state must prove the following 3 elements beyond a reasonable doubt. 1, Markeith Loyd took a motor vehicle from the person or custody of Antoine Thomas. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the taking was with the intent to temporarily or permanently deprive Antoine Thomas of his right to the motor vehicle or any benefit from it. Motor vehicle means an automobile, motorcycle, truck, trailer, semi-trailer, truck, tractor, and semi-trailer combination, or any other vehicle operated on the roads of this state used to transport persons or property and propelled by power other than muscular power. But the term does not include traction engines, road rollers, personal delivery devices, special mobile equipment, vehicles that run only upon a track, bicycles, swamp buggies, or mopeds. An assault is defined as an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of the victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then the victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means that the act occurred before, during, or after the taking of the motor vehicle, and that the act and taking of the motor vehicle constitute a continuous series of acts or events. If you find that the taking of the motor vehicle occurred as an afterthought to the use of force or violence against Antoine Thomas, the taking does not constitute carjacking, but may still constitute grand theft motor vehicle. In order for a taking of property to be carjacking, it is not necessary that the victim be the actual owner of the property. It is sufficient if the victim has custody of the property at the time of the offense. The taking must be by the use of force or violence or by assault so as to overcome the resistance of the victim, or by putting the victim in fear so that the victim does not resist. The law does not require that the victim of a carjacking resist to any particular extent, or that the victim offer any actual physical resistance if the circumstances are such that the victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. If you find the defendant guilty of the crime of carjacking, then you must further determine beyond a reasonable doubt if, in the course of committing the carjacking, the defendant carried some kind of weapon. An act is in the course of committing the carjacking if it occurs in an attempt to commit carjacking or in flight after the attempt or commission. If you find that the defendant carried a firearm or other deadly weapon in the course of committing the carjacking, you should find him guilty of carjacking with a firearm or deadly weapon. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. A weapon is defined to mean any object that could be used to cause death or inflict serious bodily harm. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. If you find that the defendant carried no firearm or weapon in the course of committing the carjacking, but did commit the carjacking, you should find him guilty only of carjacking. To prove the crime of possession of a firearm by a convicted felon, the state must prove the following two elements beyond a reasonable doubt. 1, Markeith Loyd had been convicted of a felony. 2, after the conviction, Markeith Loyd knowingly owned or had in his care, custody, possession, or control a firearm. Convicted means that a judgment has been entered in a criminal proceeding by a competent court pronouncing the accused guilty. The court instructs you that element number 1 has been agreed to by the parties, and you shall find beyond a reasonable doubt that Markeith Loyd had been convicted of a felony prior to January 9, 2017. Furthermore, the court instructs you that at the time of the offense, the defendant's civil rights had not been restored. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Care and custody means immediate charge and control exercised by a person over the named object. The terms care, custody, and control may be used interchangeably. To prove that, there's a mistake there, it says but it's to prove that Markeith Loyd possessed a firearm, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the firearm, and B, intentionally exercised control over it. In considering the evidence, you should consider the possibility that although the evidence may not convince you the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of count 1, first-degree murder of a law enforcement officer, are 1, first-degree murder, 2, second-degree murder of a law enforcement officer, 3, second-degree murder, and 4, manslaughter. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Debra Clayton is dead. 2, the death was caused by the criminal act of Markeith Loyd. 3, there was a premeditated killing of Debra Clayton. An act consists of a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Markeith Loyd did not act with premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused the death. And E, Markeith Loyd was in fact so provoked and did not cool off before he committed the act that caused the death of Debra Clayton. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. To prove the crime of second-degree murder of a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. 1, Debra Clayton is dead. 2, the death was caused by the criminal act of Markeith Loyd. 3, there was an unlawful killing of Debra Clayton by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. 4, Debra Clayton was a law enforcement officer. 5, Markeith Loyd knew that Debra Clayton was a law enforcement officer. 6, Debra Clayton was engaged in the lawful performance of a legal duty. The definition of law enforcement officer is one I've now read to you 2 or 3 times. I'm not going to read it to you again. It's exactly the same as I've read it to you before. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and 2, it is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder of a law enforcement officer, it is not necessary for the state to prove the defendant had an intent to cause death. The next portion of this is the heat of passion instruction, which I've already read to you twice. It's identical, but it's just applied to this charge, all right? If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder of a law enforcement officer. All right. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Debra Clayton is dead. 2, the death was caused by the criminal act of Markeith Loyd. 3, there was an unlawful killing of Debra Clayton by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The rest of this instruction I've already read to you. It's the same. It's, imminently dangerous. It's heat of passion. It's all the same instruction I've already read to you, but you have it here in writing as applied to second-degree murder. All right? If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Debra Clayton is dead. 2, A, Markeith Loyd intentionally committed an act or acts that caused the death of Debra Clayton, or B, the death of Debra Clayton was caused by the culpable negligence of Markeith Loyd. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence, but culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to the consequences, or which shows wantonness or recklessness, or a grossly careless disregard of the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. All right, this is the lesser included crimes of count 2. The beginning of the instruction is the same as it was for first-degree murder, but the lesser crimes indicated in the definition of count 2, attempted first-degree murder of a law enforcement officer, are 1, attempted first-degree murder, 2, attempted second-degree murder of a law enforcement officer, 3, attempted second-degree murder, and 4, attempted manslaughter. To prove the crime of attempted first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Markeith Loyd did some act intended to cause the death of Joseph Carter that went beyond just thinking or talking about it. 2, Markeith Loyd acted with a premeditated design to kill Joseph Carter. 3, the act would have resulted in the death of Joseph Carter except that someone prevented Markeith Loyd from killing Joseph Carter or he failed to do so. A premeditated design to kill means there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of a premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. To prove the crime of attempted second-degree murder of a law enforcement officer, the state must prove the following 5 elements beyond a reasonable doubt. Number 1, Markeith Loyd intentionally committed an act which would have resulted in the death of Joseph Carter, except that someone prevented Markeith Loyd from killing Joseph Carter or he failed to do so. 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. 3, Joseph Carter was a law enforcement officer. 4, Markeith Loyd knew that Joseph Carter was a law enforcement officer. 5, Joseph Carter was engaged in the lawful performance of a legal duty. The definition of law enforcement officer is the same one I've read to you several times now, so I'm not going to read it again. So is the definition of an act. So I'm not going to read it again. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder of a law enforcement officer, it is not necessary for the state to prove the defendant had an intent to cause death. Attempted second-degree murder. To prove the crime of attempted second-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. 1, Markeith Loyd intentionally committed an act which would have resulted in the death of Joseph Carter, except that someone prevented Markeith Loyd from killing Joseph Carter or he failed to do so. 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. The remainder of this instruction has been read to you before, so I'm not going to read it to you again. It's the definition of an act and the definition of imminently dangerous to another. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of attempted manslaughter by act, the state must prove the following element beyond a reasonable doubt. Markeith Loyd intentionally committed an act which was intended to cause the death of Joseph Carter and would have resulted in the death of Joseph Carter, except that someone prevented Markeith Loyd from killing Joseph Carter, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Each of us has a duty to act reasonably and use ordinary care towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide, as I have previously explained those terms. All right, so this is the lesser included attempts. As I said, the beginning of the instruction on lesser included is always the same, so I'm not going to read it to you again. You have all of this in writing. So this is count 3. This is the lesser crimes indicated in the definition of count 3. Aggravated assault are 1, improper exhibition of a firearm, and 2, assault. Before you can find the defendant guilty of improper exhibition of a firearm, the state must prove the following 3 elements beyond a reasonable doubt. 1, Markeith Loyd had or carried a firearm. 2, Markeith Loyd exhibited the firearm in a rude, careless, angry, or threatening manner. 3, he did so in the presence of 1 or more persons. If you find that the defendant exhibited the firearm in necessary self-defense, you must find him not guilty. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Before you can find the defendant guilty of assault, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Markeith Loyd intentionally and unlawfully threatened, either by word or act, to do violence to Antoine Thomas. At the time, number 2, at the time, Markeith Loyd appeared to have the ability to carry out the threat. 3, the act of Markeith Loyd created in the mind of Antoine Thomas a well-founded fear that violence was about to take place. Again, this is the lesser included crime instruction for count 4. The lesser crimes indicated in the definition of count 4, carjacking, are robbery, grand theft of a motor vehicle, and assault. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. Markeith Loyd took property from the person or custody of Antoine Thomas. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property taken was of some value. 4, the taking was with the intent to permanently or temporarily deprive Antoine Thomas of his right to the property or any benefit from it, or appropriate the property of Antoine Thomas to his own use or to the use of any person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim, when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of the victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then the victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events. If you find that the taking of property occurred as an afterthought to the use of force or violence against the victim, the taking does not constitute robbery, but may still constitute theft. In order for a taking of property to be robbery, it is not necessary that the person robbed be the actual owner of the property. It is sufficient if the victim has the custody of the property at the time of the offense. The taking must be by the use of force or violence or by assault so as to overcome the resistance of the victim or by putting the victim in fear so that the victim does not resist. The law does not require that the victim of robbery resist to any particular extent or that the victim offer any actual physical resistance if the circumstances are such that the victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of the victim. It is sufficient if the property taken is under the actual control of the victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, then you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant carried a firearm in the course of committing the robbery, you should find him guilty of robbery with a firearm. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive or the frame or receiver of any such weapon. If you find that the defendant carried no firearm or weapon in the course of committing the robbery, but did commit the robbery, you should find him guilty only of robbery. To prove the crime of grand theft of a motor vehicle, the state must prove the following two elements beyond a reasonable doubt. One, Markeith Loyd knowingly and unlawfully obtained or used or endeavored to obtain or use the motor vehicle of Antoine Thomas. Two, he did so with intent to either temporarily or permanently deprive Antoine Thomas of his right to the property or any benefit from it. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner of A, taking or exercising control over property, B, making any unauthorized use, disposition, or transfer of property, C, obtaining property by fraud, willful misrepresentation of a future act or false promise, D, conduct previously known as stealing, larceny, purloining, abstracting, embezzlement, misapplication, misappropriation, conversion, or obtaining money or property by false pretenses, fraud, deception, or other conduct similar in nature. Endeavor means to attempt or try. The next lesser is assault. I've already read you assault in the other count, so I'm not going to read it to you again, but you have it in writing. All right. If you find that Markeith Loyd committed the crime of first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, or second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in so doing caused great bodily harm or death to Debra Clayton, you should find the defendant guilty of first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, or second-degree murder with discharge of a firearm causing great bodily harm or death. If you find that Markeith Loyd committed the crime of first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, attempted first-degree murder of a law enforcement officer, attempted first-degree murder, attempted second-degree murder of a law enforcement officer, or attempted second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, attempted first-degree murder of a law enforcement officer, attempted first-degree murder, attempted second-degree murder of a law enforcement officer, or attempted second-degree murder with discharge of a firearm. If you find that Markeith Loyd committed the crimes of first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, attempted first-degree murder of a law enforcement officer, attempted first-degree murder, attempted second-degree murder of a law enforcement officer, attempted second-degree murder, carjacking, robbery, or possession of a firearm by a convicted felon, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, attempted first-degree murder of a law enforcement officer, attempted first-degree murder, attempted second-degree murder of a law enforcement officer, attempted second-degree murder, carjacking, robbery, or possession of a firearm by a convicted felon with actual possession of a firearm. The definition of firearm has been read to you several times, so I'm not going to read it again. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Markeith Loyd committed the crime of manslaughter or attempted manslaughter by act, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, or threatened to use or attempted to use a firearm, you should find the defendant guilty of manslaughter or attempted manslaughter by act with a firearm. And again, the next paragraph is the definition of firearm. I've already read it to you. If you find that Markeith Loyd committed the crime of manslaughter or attempted manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty only of manslaughter or attempted manslaughter. An issue in this case is whether Markeith Loyd was insane when the crime allegedly was committed. A person is considered to be insane when 1, he had a mental infirmity, disease, or defect. 2, because of this condition, A, he did not know what he was doing or its consequences, or B, although he knew what he was doing and its consequences, he did not know it was wrong. All persons are presumed to be sane. The defendant has the burden of proving the defense of insanity by clear and convincing evidence. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation about the matter in issue. In determining the issue of insanity, you may consider the testimony of expert and non-expert witnesses. The question you must answer is not whether the defendant is insane today or has ever been insane, but whether instead the defendant was insane at the time the crime allegedly was committed. A defendant who believed that what he was doing was morally right is not insane if the defendant knew that what he was doing violated societal standards or was against the law. Unrestrained passion or ungovernable temper is not insanity, even though the normal judgment of the person is overcome by passion or temper. Although insanity is a defense, mental or psychiatric conditions not constituting insanity are not defenses to any crime in this case. Unless there is clear and convincing evidence that Markeith Loyd was insane at the time of the crimes alleged, any evidence of mental illness, an abnormal mental condition, or diminished mental capacity may not be taken into consideration to show that he lacked the specific intent or did not have the state of mind essential to proving that he committed the crimes charged or any lesser crime. If you find that Markeith Loyd committed one or more of the alleged crimes or lesser included crimes, but you find by clear and convincing evidence that the defendant was insane, then you should find him not guilty by reason of insanity. If your verdict is that the defendant is not guilty by reason of insanity, that does not mean he will be released from custody. A law enforcement officer or any person she has summoned or directed to assist her need not retreat from or stop efforts to make a lawful arrest because of resistance or threatened resistance to an arrest. The officer is justified in the use of any force that she reasonably believes necessary to defend herself or another from bodily harm while making the arrest. That force is also justifiable when necessarily used, 1, in retaking a felon who has escaped, or 2, in arresting a felon who is fleeing from justice. Deadly force includes, but is not limited to, 1, firing a firearm in the direction of the person to be arrested, even though no intent exists to kill or inflict great bodily harm. And then the next one is the definition of firearm, which I've already read to you. It is a defense to the crimes of first-degree premeditated murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter if the actions of Markeith Loyd constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. A person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force then to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes such force is necessary. In deciding whether Markeith Loyd was justified in the use of deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based on appearances, Markeith Loyd must have actually believed the danger was real. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Markeith Loyd and Debra Clayton. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Markeith Loyd was justified in the use of deadly force, you should find him not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Markeith Loyd was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proved. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. The evidence that has been admitted to show similar crimes, wrongs, or acts allegedly committed by the defendant will be considered by you only as that evidence relates to the proof of the identity of the defendant. It is up to you to decide what evidence is reliable. You should rely on your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or has been promised immunity from prosecution, or who hopes to gain a more favorable treatment in their own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider their testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Those are all the instructions I'm going to read to you prior to the closings. Both the state and the defense have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They're intended to aid you in understanding the case. Each side has equal time, but the state is entitled to divide their time between an opening argument and a rebuttal argument after the defense has given their closing. Mr. Williams, you may proceed.
Thank you, Your Honor. May it please the court, counsel. Theodore Roosevelt said that courage is not the absence of fear, but rather it is the judgment that something else is more important. We all know now, having heard the evidence, that Lieutenant Debra Clayton was courageous. When a member of her community, Takesha Bryant, came to her and asked for help, she took action. Now, while the action she took was courageous, and that in fact is amazing, what is even more striking is something that could be easily overlooked. And that is that she never hesitated. Think about that for a moment. A woman runs up to her as she's loading groceries into her car, tells her there's a murderer in the store, and she needs help. And Debra Clayton went towards the danger. She didn't do so recklessly. She wasn't careless. She called for help, for backup on her radio. She walked calmly, judiciously towards the suspect, hand on her gun at one point, prepared. She gave lawful commands, and eventually she drew her firearm. What is clear from the evidence in this case is that Lieutenant Debra Clayton took her oath to serve and protect very seriously that morning, and that on the morning of January 9th of 2017, she honored that oath. But it is not her oath, nor is it her courage why she is no longer with us. Debra Clayton is dead because of anger. She is dead because of hatred. She is dead because a man valued his freedom more than he valued her life. And the overwhelming evidence in this case leaves no doubt that that man was the defendant, Markeith Loyd. We have presented over the course of more than a week overwhelming evidence of the defendant's guilt, not only of the murder of Lieutenant Debra Clayton, but of all of the crimes with which he is charged. Now, you've been given 60 pages of instructions. So for the next few minutes, we're going to go through all of the evidence that you heard. We're going to start with the crimes that were committed after Lieutenant Clayton's murder. And then we're going to go back and talk about her actual death at the hands of Markeith Loyd and focus on premeditation, because that evidence will instruct you and give you guidance on how to deal with the defenses in this case. So you all know by now that it is the state's burden, it's our burden to prove each and every crime beyond and to the exclusion of every reasonable doubt. You've been told what the elements of the crimes are, and those are those numbered paragraphs below each and every one of the elements. So I'm going to address a couple of things here because we understand that you're not lawyers and that 40 pages of being read to this early in the morning is not necessarily an easy thing to digest. So the first thing I want to talk about is the lesser included offenses. On following each charge, and I'll use first-degree murder, the first-degree murder of Lieutenant Clayton as an example, there are lesser included offenses. And for her charge, the lesser offenses are first-degree murder, and then second-degree murder of a law enforcement officer, second-degree murder. So significantly, you will be given an instruction by the court that you are to find the defendant guilty of the highest offense for which you find evidence beyond a reasonable doubt. So what that means is that you start with the crimes that are alleged and charged, counts 1, 2, 3, and 4, and if you do not find evidence beyond a reasonable doubt, then you move down to those lesser included offenses to see if they've been proven. Now, I'm not going to spend any more time on the lesser included offenses because it is our firm belief that you have been provided evidence beyond and to the exclusion of every reasonable doubt of the defendant's guilt of the crimes for which he's alleged. But that is why you have those lengthy lesser included offenses. It's in the event that there is not evidence beyond a reasonable doubt of the top charge type crime that is charged. I also wanted to briefly address something with you. And on page 39 of your instructions, there's an instruction about firearms. And if you recall, the judge read the charges over and over and over again. And then there was a line about firearms. What that is for, you'll find, is you'll get a verdict form. And at one of those verdict forms, it'll say special verdict. And if you find Mr. Loyd guilty of the crimes, you'll be asked to find out or make a decision whether he carried a firearm with him, whether he possessed a firearm, and whether he discharged it. And obviously all the evidence in the case says that, but I didn't want you to be confused about that instruction on pages 39 and 40 because it is lengthy. So finally, before we start talking about the evidence, I want to explain to you how the process works briefly and how we're going to go through it. Because we have the burden of proof, we're entitled to split our closing between a first and a second. So in the first closing, I'm going to talk to you about the evidence that we've presented to you that proves these crimes. I am not going to discuss insanity or self-defense much because it is my expectation that defense counsel will discuss that in his closing, and I will wait and hold my response to that until the end. So with all that said, I'd like to talk with you a little bit about the crimes, and we're going to start with the aftermath of the murder of Lieutenant Clayton. Following Lieutenant Clayton's murder, the defendant committed 4 separate additional crimes, one of which actually he was committing at the time that he murdered Debra Clayton. So the first crime is attempted first-degree murder, specifically of Captain Joseph Carter, and that's alleged in count 2. Now, your instructions give you very clearly the 6 elements that have to be proven beyond a reasonable doubt. And I'm not going to go through all of them because some of them are quite obvious. But we'll start with the first one. Markeith Loyd did some act intended to cause the death of Joseph Carter that went beyond thinking or talking about it. So inherent within that element is that we have to prove that Markeith Loyd is the person who did those things, that he's the one that committed the act. Of course, the act being firing a firearm at a law enforcement officer who got out of his vehicle. So how do we know that Mr. Loyd is the one who committed this crime? While Captain Carter did not get close enough or have the chance to get close enough to Mr. Loyd on the offense to actually identify him, he told you what he was wearing. He described his clothing. He described the vehicle that matched the description of the one that you saw video of driving out of the Walmart parking lot, and that Monica Pridgeon very clearly described in her testimony. We know, and you know from the maps that are in evidence in Captain Carter's description, that vehicle that Markeith Loyd was driving, the Mercury, was found very near from where the Walmart scene was, and very near Royal Oaks, where you saw photographs of the shots that were fired. But of course, well, you also know that the 9mm that was recovered at the time that Mr. Loyd was apprehended matched the shell casing, the 9mm shell casing that was found at the scene at Royal Oaks, a Hornady 9mm, and that the same type of unfired cartridge was found inside Mr. Loyd's car. But of course, you know that he's the one that did it because he told you that he was the one that did it. Now, Mr. Loyd gave you a slightly different version of what happened at the scene of the offense. And we'll talk about that in a moment. Now, you all have photographs that are part of my presentation in front of you, but this is a good time to remind you that every single picture that was admitted in evidence, there's a hard copy of it, and it's going to go back to you as members of the jury. So you'll be able to review every photograph if you choose to do so. So the second element is that, the third element, or the second part of the first element, is that he did an act beyond just thinking about it. And of course, that act was him firing a 9mm firearm at Captain Carter. Now, that's the appropriate time to address the defendant's claim that he was firing in self-defense. He fired a warning shot, is actually what he said. You know that's not true because you saw the photograph and evidence of the the firearm and the projectile striking the hubcap of Captain Carter. More importantly, something that was glossed over a little bit was there's a photo on your screen, AB, and there's a piece of a projectile that was recovered. But next to that projectile are two pieces of plastic, and if you look at them carefully, it's pretty clear where they came from. They came from Captain Carter's hubcap. So when the projectile struck Captain Carter's car, it leaves those marks. And that's important, ladies and gentlemen, because AB is up above, closer to the Mercury vehicle than it is where Captain Carter's vehicle came to final rest. And that's important because it shows you how close Captain Carter got to the defendant at the time. Because remember Mr. Loyd's testimony, he said he fired at the ground, or he thought he fired at the ground. And of course, he did not do so and could not have done so to be able to hit Captain Carter's vehicle. We also know that Markeith Loyd fired at Captain Carter because of the way Captain Carter described how he parked his vehicle. When he pulled in behind the defendant, he turned his wheels to make sure that he had cover from the vehicle as he was approaching the suspect. So the wheel that is struck, the outside hubcap, is the right front, which would have been exactly the wheel closest to Mr. Loyd, telling us that that Markeith Loyd shot exactly in the direction of where Captain Carter was. So that brings us to the second element. Markeith Loyd acted with a premeditated design to kill Joseph Carter. Now, what evidence do we have of that, and what exactly does premeditated design mean? You've all been read to this morning. I'm not going to read to you again, but you can see it on your screen. But what it means is a conscious intent to kill. And that conscious intent has to be present in the person's mind during the act. So then what I would give you is, all being Floridians, familiar with mosquitoes. You're sitting on your front porch, a mosquito lands on your arm. You look down and you see it, and you have a decision to make. Do you brush it off, or do you smack it? There's a conscious choice in your mind to do one or the other, and it may only take a matter of seconds to make that decision. But if you smack it down, that is an intent to kill that was formed in your mind at the time and during the actual act. And that is all that is necessary to prove premeditation in the state of Florida. And there is no doubt that Markeith Loyd had a premeditated design to kill Captain Carter. How do we know that? We know that because of the way Captain Carter described what he saw when he pulled up behind who we now know as Markeith Loyd. What did Captain Carter say the man in the dark clothing was doing when he pulled his car to a stop? He was already standing, looking right at him. Firearm, remember he told you the firearm wasn't up at that point, but he was standing waiting for Captain Carter. If Markeith Loyd's intention was to flee, if his intention was to scare Captain Carter, he could have jumped out of the Mercury and taken off running. But he didn't. He stood and he waited for Captain Carter, yet another law enforcement officer, to start to get out of his car, and that's when Markeith Loyd fired at Captain Carter. We also know, unfortunately, that Markeith Loyd intended to kill Captain Carter because he had just killed another law enforcement officer minutes before for trying to do the same thing that Captain Carter was doing, which was to take his freedom away from him. Go back to the primary instruction. Number 3, basically, is the difference between a completed murder and an attempted murder. All the elements are the same except that Mr. Loyd failed to kill Captain Carter for whatever reason, and in this case is that he wasn't a good enough shot and Captain Carter was able to retreat because he, unlike Lieutenant Clayton, was in a vehicle. And then elements 4, 5, and 6 all really address the same thing, which is that Captain Carter was a law enforcement officer on January 9th of 2017, that Mr. Loyd knew he was a law enforcement officer, and that Captain Carter was engaged in illegal duty. And we know that Markeith Loyd knew Captain Carter was a law enforcement officer because Captain Carter was driving a vehicle with lights and sirens. He had lit those lights and sirens up when he began to chase Mr. Loyd, and of course, because Mr. Loyd told you that he knew that Captain Carter was a law enforcement officer. There is no doubt, ladies and gentlemen, let alone a reasonable one, that that Markeith Loyd is guilty of the attempted first-degree murder of Captain Carter, a law enforcement officer. Now, on the screen, I've referenced that special finding and language from page 39. That's the verdict form that I was referring to that you'll receive. And it's a very simple question. Did the person have and actually possess a firearm? Did he discharge a firearm? So that brings us to the second crime, aggravated assault with victim Antoine Thomas. There's no doubt that Mr. Loyd committed this crime. Mr. Thomas described Mr. Loyd physically. He described his security shirt that he was wearing on the date of the offense. And as you can see on the screen, and you heard in testimony, he picked him out of a photographic lineup within hours of the actual crime. Significantly, Mr. Thomas described Mr. Loyd carrying not just one firearm, but an extended magazine in his other hand, which is exactly what Mr. Loyd was carrying when he went and fled. And of course, Mr. Loyd told you that he was the one that met with Antoine Thomas. Intentionally threatened by act, Antoine Thomas's testimony was that he was on the landing and that Mr. Loyd put the barrel so close that he could reach out and touch it. He could see down the barrel of the firearm. And I would submit to you that that provided an ability to carry out the threat, which is also an element of the crime, and that any reasonable person would not just be in fear but terrified, as Antoine Thomas testified he was at the time. Now, again, Mr. Loyd gave a different version of what happened to Thomas, and his testimony was essentially that it was a godsend vehicle for him at 7:25 in the morning, and that I think he actually leaned up on the witness stand and said he had the guns in his hand. And I would submit to you that that is not credible. It is inconsistent with Antoine Thomas's testimony. But I wanted to point out something else about Mr. Loyd's testimony on that point. Because, and we'll talk about this in a moment, you all had the opportunity to observe Mr. Loyd for an extended period of time. And he's a very intelligent man. And he made it clear, and you heard, that he had studied the evidence in this case very closely. And his statement about what happened with Mr. Thomas was evidence of that. Because he used Mr. Thomas's statements, are you serious, as a way to try to justify and give a story about what occurred. And that should not be surprising given the testimony that Mr. Loyd gave about how closely he looked at everything in this case. But it is inconsistent with Antoine Thomas's statement, who is not charged with first-degree murder and is not a multi-time convicted felon. We've already talked about the other elements, and it's clear, I believe, to you that a firearm is a deadly weapon. So we're going to move on to carjacking. The carjacking of Antoine Thomas. The elements of this closely mirror the aggravated assault charge. The only difference is that they're the taking of a vehicle. You all are intelligent enough to look at the elements of that, and I feel that they've been proven beyond a reasonable doubt. And there'll be a special finding verdict form for that charge as well. Which brings us to firearm or possession of a firearm by a convicted felon. Now, Mr. Loyd testified, and you know from other evidence, that he possessed multiple firearms at the time he had been convicted of a felony and not pardoned. There's a stipulation to that in evidence. And this is a photograph of the .40 caliber Smith & Wesson .40 SVE that he used to kill Lieutenant Clayton. and that you heard evidence and testimony that he possessed on the day of the crime. So, ladies and gentlemen, that addresses all of the crimes that are alleged other than Lieutenant Clayton's first-degree murder, which is what we'll talk about now. So, I want to focus, as I said, specifically on the premeditation that is necessary to prove first-degree murder. Because I would submit to you that the other elements are extremely self-explanatory and obvious from the testimony that you've heard. There's no doubt that Mr. Loyd is the person who committed this crime. He was identified by Takeshia Bryant. You saw video of a man wearing the exact same outfit or clothes that he was wearing. You know that the shell casings from his gun matched the gun that was found at the scene where he was apprehended and the projectile that was removed from Sade Dixon. We know, unfortunately, from the testimony of Dr. Joshua Stephanie, that the projectiles that were recovered from Lieutenant Clayton matched the gun that Mr. Loyd possessed. And you know Lieutenant Clayton was a law enforcement officer from the testimony of Detective Cadis, from Sergeant Thornton's testimony, and the obvious photographs and video of her walking through the Walmart on the morning of January 9th, 2017 in full uniform. So as I told you, we're going to focus on premeditation because it is the only thing that is remotely in dispute, and it goes to the defenses that Mr. Loyd has raised in this case. So let me back up. There are three reasons why we know that Markeith Loyd had a premeditated intent to kill Lieutenant Clayton on the morning of January 9th of 2017, or three categories of evidence. The first one is that he had a motivation to kill that morning. And his motive, and I want to specifically direct your attention to, this is of course just one Facebook post of several, to the second to last line. I'd rather die than live my life in a cell. It is not a secret. There's been evidence that Mr. Loyd was in prison up until 2014, and he's made it clear through his Facebook post he was not going back. Lieutenant Clayton's goal, her only goal on the morning of January 9th, was to bring him into custody. And that was one of the few things he would simply not allow. The defendant had a motivation to kill. We know that Mr. Loyd had a motivation to kill because of the preparation he took prior to ever going to Walmart on the morning of January 9th. We know that he had obtained a bulletproof vest. Right? And this is where we start to intersect a little bit with his self-defense claim. Because if you're fearful of law enforcement, obtaining a bulletproof vest in the event that you want to surrender so that you're not killed during the surrender makes a certain amount of sense. Why do you need and not just one firearm, why do you need two firearms? And not just two firearms, why do you need an extended magazine so that you can carry more bullets with you? The evidence is clear that Mr. Loyd knew well before he ever saw Lieutenant Clayton grocery shopping that morning, that if he came across a law enforcement officer who got in his way, he would kill them. And you all know from the video that that is exactly what he did. You know that because in his Facebook post, he doesn't talk just about defense, but he talks about going on the offensive. When you look at the posts, if you choose, when you go back to the jury room, all of them in their entirety, because I haven't even published them all to you at this point. I've only shown you the ones relevant to specific times and phrases.
Objection.
Overruled.
I have a motion.
I'll see you at sidebar. Mr. Loyd, you will remain silent during this time. take a 10-minute break, folks, since the jury took one. Yeah, let me just make some. All right, we're back on the record on State versus Lloyd. He's present with his attorneys. State Attorney's Office is present. State recognized presence of the jury.
We do, Your Honor.
Defense? All right, welcome back, folks. Mr. Williams, you may resume.
Thank you, Your Honor.
Oh, right.
I believe where I left off was with the statement that when it comes to Mr. Lloyd's motive and intention to kill, his Facebook post tells the story that he was going on the offensive. And not just that he was doing that, but that the purpose for doing that. In the bottom right, one of the Facebook messages, he's talking about protesting. He's talking about the need for affirmative action, but he believes that that affirmative action is violence. So I said three things in regards to premeditation for the murder of Debra Clayton. We've talked about one of them, and that is his motivation to kill. So now we're going to talk about the circumstances surrounding the murder of Lieutenant Clayton itself. Now, before we go back to the video, there's something else that even happens before any interaction with Lieutenant Clayton, and that is that Markeith Loyd arms himself. He makes it very clear in his testimony, and it's an obvious inference to draw, that he was in his car and had a choice to make. Do I take my gun with me or do I leave it here? And of course, he told you that he put his gun on his hip. Not only did he tell you that he put his gun on his hip, you all heard that he was making decisions about which firearm to take and which one to leave, because he told you he couldn't conceal the firearm with the extended magazine. So he chose the firearm that he could conceal underneath his security shirt. So we know he intended to kill going into the Walmart because he armed himself. Now, we're going to talk more about the video in my rebuttal when we address the self-defense, but there are portions of it now that need to be discussed in terms of premeditation. I'll do my best to shield this while also talking to you all. Now, just that portion of the video illuminates, yet again, Mr. Lloyd's attempts to use the evidence to support his theory as opposed to what the evidence actually shows. He told you that he ducked behind the car when Lieutenant Clayton pulled the firearm. You can very clearly see on the video that immediately to his left was a pillar. The car is here, the pillar is here, and he takes off immediately and runs to his left. He didn't duck behind the cart. There was no way to get behind the cart from where he was. And if he'd have gone to the other side of the cart, he'd have been closer to Lieutenant Clayton. We would submit to you that is a clear effort on his behalf to try to appear defensive and that he was in fear on the morning of January 9th. We know from the evidence that he attempted to evade, not to get away, but to pull and have time to pull his firearm. So when you watch the video and the clip we just showed, because again, remember Mr. Lloyd's testimony, he says he ran to the left because there were woods back there. He didn't run along the front of the building. He ran specifically to a column, which he quickly turned around as he drew his firearm. Mr. Lloyd chose his path very carefully and very keenly to make sure that he would have time and cover in the event that Lieutenant Clayton fired, which the evidence says she doesn't or did not. We'll talk about that in a moment. But even the path that he took shows that he intended to kill Lieutenant Clayton on that day. And then, of course, most obviously, Mr. Loyd did not stay behind the pillar. He did not run in a different direction in his bulletproof vest. He turned the pillar and he chased a law enforcement officer. And as he chased her, he was firing. And ladies and gentlemen, that was not a water pistol that he was firing. It was a loaded .40 caliber Smith & Wesson that he pulls and points, I'm not going to point, and has it fully extended, pointed at the back of Lieutenant Clayton. You don't have to go beyond the video, or you can go beyond the video to know that he shot her in the back, because you had the testimony of Dr. Joshua Stephanie. And you have the diagram that shows Lieutenant Clayton was shot from the rear. And I'm going to stand here intentionally so that this is not picked up by anybody but you. And you know that she was shot through the rear and that the bullet went through her body, fracturing her pelvic bone before getting lodged just underneath her vest. What other reason would Markeith Loyd have to chase a person running away other than to kill them and to end their life? But of course, that's not all we have. Because in that point in the video, you all know because you've seen it, Lieutenant Clayton is wounded. She's shot and she falls to the ground. And all Markeith Loyd had to do was run past her into the parking lot where his car was waiting. And what did he do? Instead of running past her to safety, or God forbid, turning and running the other way, a completely disabled officer on the ground, he went towards the danger. Because remember, Lieutenant Clayton is still armed. She's on her back, and she's firing to protect herself. And Markeith Loyd went towards where the gun was. Ladies and gentlemen, the only reason that he did that was because it was his full intention to end her life. Right there. Could have just run through the parking lot, never had to stop. But instead he circles. And ultimately stands directly over her and shoots her in one of the few places that did not provide her body protection. You heard the testimony from the defense expert, Mr. Robinson, who described the giant plate that was protecting her vital organs in her chest. And you can see on the video that he's standing directly over her. He chose to shoot her above the vest because it was his intention to end her life. So I told you there were 3 reasons. And of course, you can already see for yourself the third, which was the anger and hatred that Markeith Loyd had for law enforcement officers prior to that day. And you know, because you heard testimony not only from Mr. Loyd, but from the experts, that this was a hatred and anger that had been building for years. He blamed law enforcement for what was going on in the world to his people. And he used that anger and hatred to fuel his murder of Debra Clayton on the morning of January 9th. And I thought that Dr. Gamash's testimony was particularly enlightening in that we have an open window into people's minds anymore. We don't think about it when we post on social media or send a tweet, but we're sending our thoughts in the moment out into the world. And you all have an opportunity to see what was in Mr. Loyd's mind in the years and months leading up to the commission of this crime. Now, in a moment, I will sit down and the defense will have an opportunity to speak to you. And I suspect that they will discuss self-defense and insanity. And as we discussed during jury selection, and as you've already been instructed here today, it is their burden to prove by clear and convincing evidence that Mr. Loyd was insane at the time of this offense. So I would ask you, as the argument is made to you, that you listen carefully to the defense counsel's argument, but ask, is there evidence that is clear and convincing that Mr. Loyd was insane? Is it, to use the language of the instruction, precise, explicit, and lacking in confusion? Is that what you heard from Dr. Toomer? I also suspect that counsel will allege that we have not given you everything and that we have undertaken some wrongdoing. And we've already been accused of that, at least. I would ask you to remember that we provided you with the evidence that he's going to be. We called Shane Overfield and provided the projectile. Law enforcement sent that projectile to FDLE, even though they didn't know if it had significance or not. Richard Ruth tested that projectile and told you his honest conclusions, which the defense counsel agreed with, defense expert agreed with. And the last thing I would ask you to consider while listening to defense counsel's argument, particularly as to the self-defense claim that I believe they will make, is based upon the evidence that you have and what you know, are there any circumstances under which Markeith Loyd would have let Debra Clayton live that day? Let's just assume that she never fired that shot, that they say she fired. Based upon what you've seen and what you know, what evidence is there that that would have changed anything? And that he would not have hunted her and shot her from behind regardless. And then after defense counsel's argument, we'll return to you. I'll discuss insanity and the self-defense, and I'll ask this case. Thank you.
Thank you, Mr. Williams. Do they get lunch? Okay. So folks, here's what I'm going to do. I'm going to send you out for, your lunch should be here in the next 15 minutes. Instead of interrupting the defense's closing or having you sit there with your stomachs rumbling until he finishes, because I want you to be able to concentrate. Why don't you take an early lunch? We'll be back at 1:15 to do defense's closing. All right, thank you. All right, we're back on the record on State versus Lloyd. Mr. Lloyd's present with his attorney. State Attorney's Office is present. I think Mr. Mr. Buxman is here. Okay. All right. Everybody ready? Let's bring the jury back in. Gene, do I need to switch or I need to switch to the afternoon? Okay, thanks. No, no worries. Just want to make sure.
It's in here? Oh, you need it first. Okay. Okay. You can just call me over if you want. Just plug this in
Okay.
to the back here, but just motion.
Okay. Gotcha.
State recognize the presence of the jury.
We do, Your Honor.
Defense?
Yes.
All right, welcome back, folks. I hope you all enjoyed your lunch. All right, it is the defense's turn for their closing. Mr. Lenneman, you may proceed.
Thank you. Good afternoon. There's a lot I'm going to talk about in the next couple of hours. And I want to tell you that writing this stuff down is important. Because a lot of what came from this table is not supported in evidence. It's not true. Can't be relied on. And I'm going to show you how you can figure that out yourselves. In short, they took 3 posts from Facebook, one from 2014, one from January of 2016, I think the other was from July, out of the 30,000 pages or so. And they created this fabricated story, and it makes absolutely no sense. And it's going to even make less sense when I show you what this was about and how it happened, and how you don't even have to rely on me to do it. You can rely on yourself. Now, what's important to know is as jurors, you are going to be provided a laptop. And with that laptop, you can take this, which I introduced. Remember, the state only introduced a little thing that they put together. They didn't introduce everything, because they don't want you to see everything. So he didn't talk about it. This has all the videos on it, and I'm going to point out the ones that are important. And when I say I'm pointing out the ones that are important, I wrote on the board, and I'd like you to write this down, what I'm going to be showing you. I have 6 points. The first point is Lieutenant Clayton firing position. The second point is Markeith Loyd running pattern. The third point is Markeith Loyd pulling gun out. The fourth point is Lieutenant Clayton firing into the ground, the concrete ground. The fifth point is Lieutenant Clayton shooting on her back. When she was shot and why. Because remember, there's 4 wounds. The most important wound that we're talking about is the neck. And I'm going to show you where I believe this happened, and I believe is supported by the video itself. And the 6th point is, it is super important that you understand the area where this happens, and how small it was, and how quick things went. They want to hype up on premeditation. When you look at the video, you're going to know there's no premeditation there. I believe you're going to believe that it's self-defense. Now, I'm going to talk to you about insanity later, but right now I want you to focus on this video. And when you get back there, designate someone who works the video better than me. And each one of you need to see and make a decision on these points. You may not agree with me. You may agree with part of it, but you need to look at those. Now, essentially what we're talking about here is that this is the area where the store doors are. And this is the area where she runs out, or she runs up to, and fires from here. And then she starts to run across here to where she ends up laying down after she's been shot already in the abdomen. I think somebody testified, maybe the medical examiner testified, that it caused her to go down in the hip area. And you'll see in the video that the cart comes out and how the cart is still rolling when all this is going on. And what that is going to show is that this happened in a matter of seconds. Now, Detective Cadiz told you he believed the shooting itself was 6 seconds. And in my opening, I told you some things that are important. The radio transmissions are important. And I believe this is what the radio transmissions show. When she is walking up and saying, Markeith, whoever she refers to, is coming out the store now, and then whoever is on the line with her trying to talk to her doesn't hear anything. From the time that she says he's coming out of the store now and ends his radio transmission, there's about a 7-second delay. And I believe in that 7 seconds, that's when the cart is pushed, she runs, and she fires a shot. Now, he hasn't fired yet. When she fires the shot, she realizes that she didn't hit him. And she sees him coming around now with his gun. And so she starts to take off. And that's where you hear the 3 shots, bang, bang, bang. And those are Mr. Loyd's shots. And throughout this portion, remember, the first thing that you see, and I'm going to show you, is that her holding her hand extended. Now remember, these are 5 frames per second. My expert told you that TV is like 40, 50, 60 frames per second. So you're not going to see everything. So you have to really look closely at what's going on. And at some point, you're going to have to make a decision on your own individually whether what I say is correct and whether you believe it. And I will show you how I think I can prove that to you in a minute. She never drops her gun. She's running, she fires a shot, he starts coming towards her, she's running away, and at some point she fires into the ground, which you can see hit the cement in the middle of the driveway. She never drops her gun. She falls, but she turns over and she's continuing to fire her gun. Now they want to talk about execution. This is not even close to execution. 6 seconds. Being fired upon, defending yourself, trying to save your life while somebody is trying to kill you. Lieutenant Clayton is a trained police officer. And I'm not here to judge her or what she did. You guys have to make the decision what you think is important. I'm not here to say that when she held up her gun and fired, that was unreasonable. Maybe she thought he was facing her. But you can clearly see that his back is to her. And in the state of Florida, a police officer is not allowed to kill someone in a chase, even if they have a warrant, by shooting them in the back. And that's exactly what happened.
Objection.
Sustained. Rephrase.
All right, I'm going to go through. Ted, could you move this part here? Thank you. I'm going to leave this up here so when we go through the video, yeah, thank you. Yes, thank you. Thank you. Thanks. This is in the Walmart original file. And we're going down to the rooftop cam GM to N2. Now there's only 2 of these videos where you actually get to see the interaction as it occurs. There is other videos on here that you can see if you look at when she's walking across and she's holding her gun, and when he's walking out and him breaking away. You can see all those, but I think these are the most important 2 that I'm going to direct you in. As I said, I am not a professional, but you can do this, and we'll be doing it in the back. And you may have someone who can control a computer better than I can. But I'm going to try to stop and show you points that I think are important. The time is around 7:18. That's Miss Bryant walking away. Okay, this is her running up. You can see that blue pole that I was talking about. You can see the columns. 1, 2, 3. This. He runs out this way. He did not remember when he put it down with the green pen, but he runs out this way, and then he changes directions and runs. He goes on a wide angle, and then he comes back around, and I will show you where I believe he pulls his gun, and then we'll talk about more. Okay, so this is when she has already, what I believe, fired a shot. And I'm going to show you, in this particular case, something easy for you to look at, but what I'm suggesting is that you should go and get to the exact point where she is pointing her hand. And this is the one that we have taken. This is when he has not fully come around yet, but he knows he's being shot at. This is her arm extended. Right there. That's when she fires a shot. So you need to come up to the location when she fires a shot and you will see the arm extended. Remember, we're talking 5 frames per second, which is much lower. So you're going to have to work that through. But this is an actual still photo of where she is in that position. Okay. Now I want you to focus on Mr. Loyd. He has come past that pillar, and he is headed now in the direction, the opposite direction away from the street and the location where she is at. Here, he has pulled his gun. She has already fired, and she starts to move away. Now watch, at this point, he has not pulled his gun yet. He is in the opposite direction of her. This is when she fires. This is what I was trying to pull up before. You see her right arm extended. And he's already been shot at, and he's starting now to go in her direction, because as he testified, he fears for himself. And this is reasonable person fear. This is not insanity. We'll talk about insanity later. Let me try that again. I'm going to try to stop it right before he makes that circular pattern where you can see at the pillar, if you look through, that he has not pulled his gun. Okay, now, look where his hand is. This is when he's reaching for his gun. She has already fired and she's starting to move away. Pulls his gun and continues the gun battle. Now, what I ask you to do is you have as much time as you want. I want you to look at my hypothesis that, like Dr. Gamache says, my hypothesis of what I see is happening and whether you believe that to be correct. This is up to you. You have a laptop, you will have this flash drive, you will have as much time as you need to go through it. So that would have been the point of him running and turning and then pulling his gun. Okay? Now, she's running away. She's already fired at him. Now he's giving chase to her because she's still a threat. You can see she has her gun in her hand still. She hasn't dropped her gun. As a matter of fact, in a second, she's going to shoot down into the concrete. Right there. See that smoke? That's the concrete she shoots down at. So he's hearing gunshots. This is all happening in a matter of seconds. Now this is the other camera from the rooftop where we're going to actually see what takes place in this area here where the shooting continues. You're always moving up to 717 in that area. Once you go through this, you'll easily see where you need to go and look at. Now, the first thing I want you to note is the cart, as I told you. There's the cart. So this cart was pushed from the other side of the wall, not where the columns were, but from the other side, as you heard testimony and you saw yourself, him going out that door, and the cart gets pushed, and now you're seeing where the cart is rolling from. This would suggest that you can kind of estimate what the area is. You know where the end of the concrete is and when the pillar and the open area begins, and you know where he was coming out the front door. So the reason this is important is it signifies clearly that this is happening in very short time. Okay, so now she has falling, and she's on her back. She still has her gun, and her legs are up. Now you just saw her raise her gun. He has his gun, she has her gun. Now, this is what I want you to watch for. You heard testimony from Mr. Robinson about her vest, where her vest is, and where the wounds are. The one wound that we're going to be talking about here is the wound that's right above, and the doctor says that that's probably the fatal, he does say it's the fatal wound. And that there was one other wound that could be fatal, but it would take longer. So now she's on the ground, and what I want you to watch is at some point her body is turned, and her gun is up, and Mr. Loyd is in front of her, and I would suggest that that is the shot that he makes. And I'll tell you why I suggest it. Because as soon as he does that, even though he goes around the body, as soon as he does that, you will see her arms relax. So the shot was not overhead execution, as the prosecutor has said, which absolutely is incorrect, even according to their own witnesses. You heard the testimony that when someone is shot with a firearm, I think it was Mr. Ruth who said that one of the things you look for in close range wounds is soot. That's the gunfire stuff we see when we watch TV and we see slow motion, a gun is fired and all this stuff comes out. That's an indication that the gun is closer than 3 feet. If it's more than 3 feet, there's not going to be any soot. You heard from Ruth, you heard from Robinson. There was no soot in these wounds. In that wound either, the neck wound. So I suggest that when he is running around, if you look at the measurement of where his hand is, because he hasn't put his hand down, he tells you that he stops firing when she stops firing. She has stopped firing, but he's still checking. So when you see the gun around and down, there are no shots fired. And we know that because that gun was less than 3 feet away when that happened. The other issue, which is important to remember, is that shot that he fired and killed her was in response to her holding her gun up. And we know for a fact, based on the number of projectiles that were recovered, around her body. And if you look at, this is the kind of legend, and it says you're looking for 9mm Luger. And so we have D, E, G, H, I, and B and C are over here. So all her shots that were fired over here was in the seconds that occurred between the time that Mr. Loyd turned around after believing that he was going to be shot and the end moment when he shoots while her hands are still up, her arm is still up, and her leg is up. And let me show you that. Again, I am delegating, obviously, the responsibility on the conclusions that are made here, because what I say is argument, what Mr. Williams says is argument, for you to look yourself and see if what I'm saying is correct. Okay, he's already fired the shot. She had her leg up, and I'm going to go back. See if I can catch that. You'll see after that shot that her arms relax. Still didn't catch it. Arms extended. His arm is extended. She's firing. She has to be firing. There are 8 casings that expel from her gun. Now, as he goes around, watch her arms go down. She's done. And I don't mean to be disrespectful. She's no longer firing. He's no longer firing. And as I said, this is something that only you can decide if what I'm saying is correct. And what is the point, what I'm saying? The point here is that if he's fired upon first, and he believes that his life is in danger, and he has a firearm, and he's going to defend himself, then the minute that he turns around and sees her with a gun, he's not going to stop firing until she doesn't have a gun or he's not in danger anymore. To think otherwise is not plausible. To think that you can just stop in midair while she still has the gun, because she fires down on the concrete. To think that you can just stop like the state is suggesting, which makes absolutely no sense. And they're suggesting without showing you this. And they never wanted to show you this because they have problems with this. Because what it shows is exactly what I'm saying. You make the decision for yourself, of course. But once that gunfight is on, once the first shot is fired, and now he's reacting, and she still has her gun in her hand, and she's still firing, in a matter of seconds, what does the state want to happen? For him to stop and run away while she has a gun pointed at him? After she had fired at least twice, first time at the front, the second time on the concrete, and then we know a bunch of times when she falls down, they're still firing at each other. He could not stop in his tracks. He could not walk away. Yes. Have a moment, Judge.
Yes, sir.
Judge, can I have a moment to look through the state's evidence?
You can.
Thank you. Oh, yeah. You're right. I'm showing you what's been marked as 2L or 21, exhibit for the state. This is the angle that we're talking about. Her body is flipped this way, and he's standing over there. And if you see At that time, she has her gun up, and she's shooting, and he's shooting down at her. If you look at the placement of her body and the placement of his, this is absolutely consistent. Now, if you remember, Mr. Loyd said, and I think it was only on the last shot, that he was shooting at the vest. And I had to put the evidence in that showed the actual vest in her shirt, location of the bullet holes. The important one was the shot to her neck, which, as you heard, ended up just being above where the vest is. So I ask you, there are a lot of other videos on that. There are obviously the section that is marked Loyd Walmart Originals. Those are all the lengthy, long, from 6:30 to 7:30 or whatever. You can move ahead. You can look for when her car pulls up, which is sometime around 7, when Mr. Loyd was already in the store. We know that because of the camera that is at the front of the door. It shows him coming at 6:44, shows her coming at 7. The state argued in their opening statement that he had to know her car was out there. They're just throwing things together, folks. They don't care about the accuracy of this. They want to inflame your passion that you've got this beautiful police officer who is very meaningful to the community and, of course, her family, and dies in this tragic incident. They're hoping that you're going to set aside the logic of the events that occurred and just convict them. And they try to do that through this really weaselly approach of using
Sustained.
this
Mr. Lund.
really misrepresentative approach of saying he had these 3 posts, therefore that was his motivation to kill her. It's ridiculous. It's a ridiculous argument. That argument is only directed to inflame your passions, to forget about justice, and to think about retribution against Markeith Loyd. You can't rely on, in my opinion, very much of what they say. Mr. Williams did this whole closing argument about how Markeith was looking to kill a police officer, based on these posts that were, one was two years old. The newest one was 7 months. And you heard Dr. Toomer explain those in the context of the bigger thing. And you heard that Markeith say that all those posts were written at a time when the police were killing young men, young black men. And you knew about his passion and his beliefs, whether they don't rise to all of our levels because they're fixed false beliefs, but you know about and heard about that. Yet they're trying to distort this because they don't have the evidence necessary to convict Mr. Loyd of first-degree premeditated murder. Now, there's going to be other charges that you're going to hear about. Heat of passion. If you find heat of passion on a first-degree murder charge, you can't convict a first-degree murder. And it will explain that to you. There's going to be lessers of second-degree murder, which talk about different state of mind. And you are more than welcome, obviously, to look at all of those and see what applies. The only one who would go to a penalty phase If you convict them of anything but first-degree murder charge, case is over. Ted, can you grab this one? Thanks. So who is Markeith Loyd and where do we begin? We begin in 2014, July. Mr. Loyd gets out of prison then after serving a lengthy sentence for drugs. He admitted that he was selling drugs at a young age, which isn't unusual, especially in lower economic areas. People will have money, they can't eat. He knew there was a time when his family didn't have food and he had to steal. And so that's where we begin. And Markeith gets out in July of 2014, and he wants to make a clean break. He wants to start over. And we have absolute evidence that from July of 2014 up to the time when Ms. Dixon was shot, that he is doing things to change his life. He is working hard on multiple jobs. At some point he had 4 jobs. He's making decent money, so much decent money that in his logic, even though he's a convicted felon, that he doesn't want to give up that job even though he was robbed twice a gun. So he goes and gets done, starts carrying. And it may not be the logic that I or you have, but Markeith is doing good. He's got his own house. People are living with him. He has multiple relationships. And so during this period, though, he learns how to post on Facebook. And you could be sure that many of the posts that were in Facebook, just like the one that we read that Dr. Toomer talked about, that he was on the exterior that way too. He didn't trust white people. He didn't trust police officers. He was attached to a system that from a very young age created or fostered this belief. And I suggest, when I say fostered this belief, that it started at a very young age. And if he was never having a mental illness, he would have never been to the extreme that he is. But because he had a mental illness, his beliefs went this way. They were irrational, they were false, fixed beliefs, delusional. Yet he continued to live a life where he's working and doing what he wants in terms of living his life. And then we have this event that happens in December of 2016 involving Ms. Dixon. And Dr. Toomer talks about these posts that he had and why they are related to this fixed false belief. And so as we lead up to this incident that occurred with Ms. Dixon, which, as you know, you can't consider, we know that Markeith Loyd is never getting out of prison, ever. You know that
Objection.
from the very beginning.
Sustained.
The judge told you. Life without the possibility of parole.
Objection.
Sustained. Move on, Mr. Lunneman.
So you can't consider that. But what you can consider is, we know that there is somebody who has these fixed false beliefs going into a situation in December 13th, 2013, where an event occurs, and you heard 2 sides of it. You heard Mr. Loyd's side, you heard Ron Stewart's side. We're not here to litigate that issue. That stuff was being offered for Markeith's state of mind at the time, and what happens when he leaves there, which he finds out shortly after leaving there, that the press is lying about what had happened at the Dixons. And he becomes fixated with it, as he has become fixated with many things in his life. This was another one. And this is after he killed his 2-month-old child, in which he told you that he was attacked, and he started cheating. And these are the stressors that he's feeling. And so he starts to get his niece to reach out to both the press and the police with the enticement of, get the press, tell the truth, then I will turn myself in. And that doesn't happen. Because the press tells, or the police tell them that we can't control it, right? And his niece goes in and tries to do it for her, and some unfavorable things happen, rejected, they take a story and make it different than it was really. So now we have this super added stressor with the stressors he's feeling already in his life. And as Dr. Tudor told you, that Markeith had believed the police were trying to kill him for some time. But I suggest, unlike what the state is alleging, that the only time that Markeith would react directly is when the police officer is actually trying to. Because we know in Carter's case, Captain Carter, that he shot at the wheel, which is on the other side of the wheel. And he shot once, unlike what Carter said, twice, because we didn't have any casings or projectiles that were matched to his gun, other than the one casing and the one projectile. And so thus begins, a heightened state of mind where he is believing the police are going to kill him. And we start to see what unfolds as this, this supportive reaction to this delusional thinking. I mean, many of us in this courtroom have religions, we have beliefs, we have faiths. And many of us may have a belief or faith that allows us to praise God, talk to God. But he believes that God is talking back. We believe that by signs. He was giving signs that God was talking back to him. And so he leaves Dixon. This event is unresolved, involving the police helping get to the truth. And we know, based on what Ronald Stewart said, we know part of the truth was Sade had a gun. And we know it's not in the car. And so now he has all these unresolved issues that are creating a heightened state of delusional thinking. And he goes out and he begins to live in the woods in Orlando. After committing this crime, he's living in the woods. He's staying at some trap houses where drug users stay. He referenced them as homeless people also, that they wouldn't ever say anything about him or know about him being involved in the Dixon shooting. And the delusions continue. has this belief that he's going to be killed by the police. So one day, his story is, he goes out to get some food or get whatever, and he runs into this guy who has a vest, a bulletproof vest. And he, right away, he believes this is a sign from God. As he has said throughout this whole entire episode, leading up to his arrest, sign of God, sign of God, sign of God. And I suggest that that's part of the movement in conjunction with other people. So he gets his vest, and he pays $200. He has $200 because he was making $1,000 a week at the chicken place. He was working at the chicken place when he went to see Miss Dixon. So he has money on him still. But he can't go anywhere to buy anything because he's concerned that he's going to be seen and put himself at risk to be killed. So he tells you he loses about 40 pounds from December 13th to January 9th. Lieutenant Clayton was killed. And after he gets his bulletproof vest, he wants to test it. Because he's seen on TV that you can shoot to the vest and it will knock you out. He wants to test to see if it's working. That's not very logical. I can't say that it's related to the mental illness, but I would guess. And the guy stops him and says, "You can't do that. You can't test it." He doesn't test it, but he begins to wear it. Now, Mr. Williams got up there in his closing argument and talked about how this was part of the master plan of Markeith Loyd. He gets his vest because he wants to kill cops. There's not 1 ounce of evidence. When you listen to Mr. Williams, first of all, when you think back to what Mr. Williams said, ask yourself, what evidence supports what he said? Does it make sense? Or is he just making something up? Try to take us down this road of emotion and anger and hate and convict Markeith Loyd. I would suggest that's it. Because for someone to come up with a desperate story like that.
Your Honor, when we approach
Sustained. Let me see the attorneys at the bench, please. Sean, can you check your mic, please? Make sure it's on.
Yes.
You may?
Yes, it's on, Judge.
All right. Yes. I wasn't going to start without her. All right. You may proceed.
Thank you. So while he is living in the woods, he decides that he wants to go to Walmart. And he happened to be driving by. And he told you the reason why he wanted to go by Walmart. I mean, I think it's an original reason. What he said was that he had to use the restroom. And he also told you that he wanted to try to get some food and supplies. because he hadn't been able to eat. And so he pulls his car up, and this is 644, and he drives, parks in the parking lot, and you see where he had parked, and he goes in to Walmart wearing a security vest that has security on the front, and he's wearing a beanie, and he has his bulletproof vest underneath him, and obviously he has one gun on him, and had left one gun in the vehicle. And he goes in, and he walks around and does shopping. He uses the bathroom, and at some point he sees Lieutenant Clayton, and he avoids her. And then he goes and checks out with his items, and as he's checking out, Miss Bryant actually came to the line that he was at and kind of went in front of him, and she ended up at some point recognizing him. And as soon as she was done, she walked out and spoke with Lieutenant Clayton. Meanwhile, Mr. Loyd doesn't know anything is happening at this point. He's pushing his cart. He goes, you see him go through the front door. We have video that shows Lieutenant Clayton walking away from her car through the glass. All you can see is that she has her hand on her gun, and she's using the radio. I think Detective Cadiz talked about that as well. And so she goes and starts walking to the front entrance. And meanwhile, there are some radio transmissions that become important that we get to hear, with her at some point saying, first she says the initial that Markeith Loyd. Someone told me he's involved in a murder. And as you listen to her, you can clearly tell she has never heard of Markeith Loyd. She does not know who Markeith Loyd is. But she's been told by a member of the community that Markeith Loyd has this warrant for murder. There's no question about that. So she gets on the line, and she goes to an emergency channel, and she begins to walk over there. And her next transmission is, they're asking, I think it was Sarge, what are you doing? What are you doing? And she's saying, I'm just walking up. He's coming out the door now. And then that's the break. And that's the 7 seconds that I'm talking to you about, from the break all the way up to the shots. And you don't hear her shot on the radio, because she doesn't get on the radio until she had fired her shot, and she says that she's in pursuit. So she says she's in pursuit, and then you hear bang, bang, bang. And so what had happened during that incident at Walmart is that as Mr. Markeith Loyd is pushing out the cart, he sees a gun that's pointing towards him. He says he wasn't absolutely sure until maybe retrospectively that it was a police officer, but he may have thought it was a police officer. And it really doesn't matter, because he turns to leave and he runs. He's running away from her. He doesn't confront her. He doesn't take her on. He runs away from her. And his goal is to go to the woods. He tells you that. So as he runs away from her, she is trailing him in the front. So when he breaks, and you can't see this, so I imagine, based on where she ends up, she breaks and starts to run. And Mr. Loyd gets to a point where he is going to the woods. And I can play it for you. It's on that video. I don't want to kind of waste the time, but there are 2 videos of drone shots involving the Walmart store. And you can see there are clearly woods across the street from the front of the Walmart. And that's where he was going. So he's headed there, and as he starts to run, he sees her. He sees her out of the corner of his eye, and he changes direction. He begins to run away from her again. It's a little wider when he turns, because this is what happens. He turns, she shoots, and thus the gun battle happens. That's exactly what happens on the film, on the video. And you saw the video. You have plenty of time to look at the video, evaluate the video. I'm not going to get any, I've already talked to you about what I think had happened, and I've covered that. So Markeith Loyd leaves and gets in his car. And he is clearly, he knows he's killed an officer. I mean, she's in full uniform. And so he's now trying to get away. Now, in terms of getting away, there's no question he's a convicted felon. You can put check mark by that. He's guilty of carrying a firearm and being a convicted felon. But what happens then is he drives away, and at some point he sees Mr. Carter, Captain Carter, turn around and put his lights on. He's in an unmarked car, but it's clear that he's a police officer, too. And Markeith turns into this apartment complex. When he turns into the apartment complex, he drives up and at some point stops, and he sees or notes that Carter is behind him. Captain Carter is behind him. So he gets out and he fires a shot at the wheel. Not at Captain Carter, not 2 shots, fires a shot at the wheel. Now you will see with every charge that exists, there are lesser included, as Mr. Williams told you. Lesser included offenses. So the most serious offense here is attempted murder, first-degree murder of a police officer. I suggest that he's not guilty of that because there's no premeditation. He's shooting at his tire. He's not shooting to kill him. And this is important. The premeditation instruction and understanding the premeditation instruction is super important because it's the state's requirement that they prove premeditation on the crimes that include premeditation. If they don't prove it, you cannot convict Mr. Loyd of any of the crimes, which is the crime involving Captain Carter and the crime involving Lieutenant Clayton. If you don't believe that they proved premeditation beyond a reasonable doubt on those charges, you cannot convict them. Now, you can convict them of lesser charges. The lesser charges are second-degree murder, manslaughter, attempted second-degree murder, attempted manslaughter. Those are all crimes. But they have to prove to you beyond a reasonable doubt that premeditation was shown. And so he flees from Captain Carter, and at some point he discards his clothes. That may have been after he met with Mr. Thomas. And Mr. Thomas said that Markeith pointed a gun at him. Mr. Thomas could have believed that Markeith pointed a gun at him. Markeith says he held the gun up, showing him. When you look at a charge like robbery, it really doesn't matter. You don't have to point a gun. Because someone's showing you, hey, give me your keys. Give me your keys. That's still robbery. So you have to decide what you believe and what applies to that particular charge. The carjacking, there's lessers. That's something you need to look at yourself. Now, going back to the Walmart, there were 3 women that came in and testified that they were witnesses at the Walmart. Ms. Bryant, Ms. Johnson, and Ms. Pridgeon. Let's start with Ms. Pridgeon. Ms. Pridgeon claims to have seen a lot. Hold on. I was reminded that in Mr. Thomas's case, he came in here and admitted that when Mr. Loyd first approached him, he said something to Mr. Loyd like, "Are you serious?" And I think that that's evidence that you can look at in regards to whether the gun was actually pointed. And if the gun was actually pointed, someone would say, "Are you serious?" And, you know, I don't think so. If I can have a moment, Judge.
Yes.
And also, if you remember, I tried to refresh his recollection about that statement. Are you serious? I gave him a statement. He said it wasn't in there, but he said it. That's something you can consider. All right, now I want to talk about, and then of course you see he leaves the area, he runs through a fence, then he ends up leaving the car at an apartment, and he ends up telling you that he took a bus, 3 buses I think he said, and then he ends up in front of Volusia, in Volusia County. So now I want to talk a little bit about the investigation that occurred at the Walmart. As you recall, Detective Cadiz was the lead detective in that case. And the issue that you really need to decide in terms of Detective Cadiz, the Orlando Police Department, the way the investigation was conducted, is whether there was a conflict of interest that existed at the time, whether that interfered with their ability to do what was important in the investigation. And I suggest there's evidence that it did. Detective Cadiz tells you that without question he had conversations with Mr. Wood, and that he used some pretty heavy language and comments about Mr. Lloyd, including Mr. Lloyd not living. And when I cross-examined him on that issue, he admitted those, and he said he had a relationship. I don't think he said he had a personal relationship, he had a professional relationship with Lieutenant Clayton. And so we get to the investigation now. So this incident has just happened, 7 o'clock in the morning. Living Good, CSI, Living Good comes out. She's the main person who's doing the collection of evidence and actually taking photographs. And one of the things she does is she, can you give me the, one of the things she does is she photographs and documents where items are discovered. And the state has these smaller versions and evidence as well. So what we see here is the area where Mr. Lloyd was, the area where Detective Clayton came out of the land, and then we have the casings, which are important, because the casings show where the proximity of the bullets being fired. Now, we know that there is one casing missing, unless you believe that Lieutenant Clayton didn't do what other trained officers did and put 16, which one in the chamber, 15 in the cartridge. Lieutenant Clayton was significantly experienced. I don't think she would have done that. So the importance of the set of these casings is it shows where the casings landed after a shot was fired. So essentially you have up here, this is R and this is Mr. Lloyd's gun. A is Mr. Lloyd's gun. All of these except K, well, K is also the gun that's belonging to Lieutenant Clayton. All of these belong. Q is, must be a different piece of evidence that the state can put on here. But all these other ones are casings required. Why is that important? Because we have a gun battle going on. This shows, imagine 8 shots, near 8 shots. At the same time your gun is going off. That's probably pretty loud. Imagine having the gun pointed at you while this is happening.
Sustain.
And so these become important because it shows the different locations. And what we know is, generally speaking, that when a firearm, according to Mr. Robinson, who is significantly experienced, when a firearm is fired, the casing ejects to the right, and he said about a 25-degree angle. Now, Cadiz wouldn't say that. Cadiz talked about going to the firearm range, not having 16 gun, can't tell where cases go, doesn't make sense, there's so many variables. And I suggested they're saying that illegal. But we know that there is one casing missing, and we have K over here. What I would suggest is that K comes from when she is running across here, and she's firing at Mr. Loyd behind her. That's where you see K. Because remember, it goes right out and right into whatever.
Mr. Lenneman, one of the jurors is having trouble seeing you're standing in front of the exhibit. Yeah. Thank you. Can everyone see the exhibit? All right, go ahead, Mr. Lennon.
So where is the casing in the shot that she fired at Mr. Loyd initially? Now, Mr. Robinson put together a chart, I'm sure you remember it, because he wrote on it, I think, with green marker. So I'm going to ask you to rely on your memory, because apparently I'm going to try to get that from Mr. Robinson.
Objection. Facts not in
Sustained.
evidence.
We don't have
I'm
it.
sorry.
Facts not in evidence as to Mr. Robinson.
Sustained.
We don't have that drawn in here. But I would suggest what he says is that she's firing from up here, which is she's firing from right here. If you look at the video, you can count these, you can see those. And so that is approximately, I guess, here. We know that we have the banisters. But wherever she's firing from, you heard Mr. Robinson said that it would eject, and he showed you kind of an angle. Like the first one I asked him if she was pointing, I don't remember if it was an angle, the first one, or whether it was straight, but I asked him to do two, and he drew a line where they were going. You have to rely on your memory. But I would suggest that one of these, the casings, is from that fired shot. The only other explanation is a missing casing that was not recovered. But I would suggest this shows this is where that casing would have ended up. And so it's important to know that when you look at the evidence and the consistency of the evidence, it's important to keep in mind all the things that are being argued and said. Whatever argument I make, whatever argument Mr. Williams makes, you need to look at the evidence and see if it supports what we're saying. Now, the next thing we deal with is a situation where at some point in the investigation, they recover a projectile, and it's collected by Detective Ogre. Now, why is that important? There was a conflict that went back and forth, remember, between what CSI Livergood said and Detective Ogre about him calling her to come out. She said she never got any call to come out. And then both Overfield and Detective Cadiz coming in here and saying that, oh, you know, it looked old and it wasn't really important, that's ridiculous. In a homicide investigation where you know killing of a police officer, they're going to seek death, for them to become sloppy about a piece of evidence because they thought it was brains. And you heard Mr. Robinson say that, you know, the abrasion comes from hitting off things. And you saw yourself what we put as evidence. And Q13, which is this one, is that projectile. And we put this into evidence, and none of them look any different from the other. So whether it was being sloppy, not caring, not being concerned, feeling that the investigation is wrapped up, they have Markeith Loyd, they know who he is, they're going to eventually get him. I don't know why that happened. But what we do know is both their firearms examiner and mine both agree that there are consistencies with the type of ammunition that she was using in Winchester. And the Q13 and the Q4, which is the Sade, 9mm, which was Lieutenant Clayton. There are consistencies. And so that consistency would certainly support what we have said from the very beginning, is that she fired and it ricocheted and they found partial bullet. Now, can you say that definitively? Absolutely not. There's no question about that. But it's important evidence because there is consistency. It wasn't fired by the 40. It wasn't fired by the 40, and certainly they said there could be other guns. But what is the likelihood of a projectile being found in Walmart that has consistency with the Sade after a shooting had happened? That it would be another gun. Maybe there's some, but I would suggest it's important evidence to support what we're saying. And the other thing Detective Cadiz does is that as soon as they figure out that there's a Walmart video, he goes and directs, I think it's Mr. Williams, is the person who works for them, video person who works for them, and collects the Walmart video. He directs them to create 15 stills. And he admits that the first still that he created was when Mr. Loyd already had his gun out and was pointed and chased against Lieutenant Clayton. And I say that's usually important because it shows the conflict. And whether it was a concern that perhaps Lieutenant Clayton did fire, and they didn't want to put her on that spot, or that they wanted to stay away from any evidence of her possible firing. I don't know what their motivation was. But what is clear is there appears to be a conflict that exists between Detective Cadiz and the Orlando Police Department in regards to this investigation. Now, I want to talk about Dr. Toomer. Because Dr. Toomer is the only doctor that came in here shared with you a significant amount of his communication with Mr. Loyd. And I'll talk about the other two doctors in a little bit. Dr. Toomer is an African-American doctor. He told you straight out why he doesn't believe in the death penalty. And he told you what he reviewed and what the work he did. And Dr. Toomer made it apparent that in dealing with the investigation of someone's state of mind, mental health issues, is that you have to look to the totality of circumstances. You just can't pick out a book like it appears their experts did on the DSM-5, which Dr. Toomer told you is not the all of evaluations, and do a little checklist like their doctors did. Dr. Toomer told you that he looked at the Facebook pages and he told you about what he saw. Disjointed, delusional thinking, false fixed beliefs. He told you why about the KKK and all the issues related to that. Mr. Loyd's firm belief that the white man was trying to kill him. And that's important here because what we're exploring is not only the moment in time when Mr. Loyd is involved with Lieutenant Clayton in a shootout, but we're talking about the time leading to it and the time after it. And Dr. Toomer told you that Mr. Loyd had been fixated for some time on the police trying to kill him. And he also had been fixated for some time about the injustices of racism. How when Mr. Loyd was a boy, he began to explore the issue by seeing and being exposed to Roots and other shows, which includes Mississippi Burning. And so what we see here through the testimony of Dr. Clayton is that through a lifetime of trauma and exposure to this issue involving racism, that at some point mental illness becomes a part of Mr. Loyd. Now, does one go with the other? No. There are people who do things and say things and may sound crazy, but in the end, they're not mentally ill. But in this case, we had Dr. Toomer explain to you the symptomology of the mental illness: schizophrenia, bipolar, manic depression, delusional thinking, PTSD. And he explained to you why he believed that those were relevant in existence with Mr. Loyd. And he came to the conclusion, after his evaluation and determination and study of Mr. Loyd and the events that transpired, that Mr. Loyd did fit into the two prongs of insanity. He was mentally ill, and though he knew right and wrong, let me double check because I want to make sure I got the right prong. although he knew what he was doing and its consequences, he did not know it was wrong. That's the prong two. Now, we have the burden in this particular case. Normally, the state has the burden of proving their case beyond a reasonable doubt. Here, we have the burden of proving clear and convincing evidence. And the clear and convincing evidence comes from Dr. Toomer and the events that has transpired throughout this trial, including Mr. Loyd, who does not believe he's mentally ill. Mr. Loyd told you he doesn't believe he's mentally ill. But we hired a doctor because we thought it was important or had the opinion otherwise, and he independently investigated the circumstances surrounding the events leading up to Mr. Loyd's situation with Lieutenant Clayton and that, and he came to a firm conclusion that Mr. Loyd was insane at the time of this incident. Now, the issue here is there are many people who think that insanity is just defined by outward, crazy behavior. And if one would look into their life and to the circumstances they've experienced and the people they see, one would realize that there are internal factors many times that dominate an individual's psyche, their mind, and that you don't always see it. And I would suggest to you that maybe you did, maybe you didn't see something when you heard Mr. Loyd. But the issue is if you believe Dr. Toomer's testimony, then you have to find, and it's clear and convincing to you, you have to find Mr. Loyd not guilty by reason of insanity. So I didn't get to finish talking about Ms. Pritchett. Ms. Pritchett was out in the parking lot. She was in her car. She had her window rolled down. She talked about what she had seen, what she hadn't seen. And I would suggest that she wasn't being completely frank with us, because she completely left out that she had originally said in her statement that she heard them talking about a shoplifter. And at some point in my cross-examination, I said to her, would anything refresh her memory? And I was going to give her a statement. And she said, no. What does that mean to you? That means she has some kind of interest in her mind of giving testimony a certain way. I don't know why. But I would suggest that you evaluate her testimony. As far as Ms. Johnson is concerned, Ms. Johnson didn't actually see the event. She was inside the store, but she claims that she said she saw the gun pointed by Lieutenant Clayton. She saw that, and she said that she heard one shot first and then other shots, which is consistent with what happened. You heard from Dr. Mayer, and why is Mayer important? Mayer was asked about his opinion about Markeith Loyd's insanity, both at the time of the Dixon case and the time here. He said that during the Dixon case he wasn't insane, and we did not use insanity in that case. And he also said that he had not done a full evaluation to make the determination on this case. Now, I believe the reason they called Dr. Mayer in was because on cross-examination of Dr. Toomer, Dr. Mayer Mr. Williams had said, isn't it true that you looked at Dr. Mayer's evaluation and he found Mr. Loyd not guilty, or that he was not insane at the time of the offense? That's exactly what I believe happened, okay? And he said at first, he was like, I reviewed his report, maybe I know that. And then I got up on redirect and I said, doctor, were you given Mayer's stuff from the Dixon case? He said, yes. Were you given anything else other than the Dixon case from Dr. Mayer? And he said no, because he wasn't. So I think that's why they called Dr. Mayer in, but Dr. Mayer tells us something very telling. He tells us when you heard testimony about a test called the MMPI-2R. And that test is basically to determine many issues, including the issue of psychosis. And Markeith tested very high, you heard from Dr. Mayer, on the psychosis end. But he also tested that he was underreporting. And the importance of underreporting means is that he's making himself look less crazy than he really is. And what I suggest in that case, because I asked Dr. Mayer, do you ever have issues with African Americans trusting you? It says it happens all the time, has to build trust. Sometimes it takes a while. In this particular case, I think he only interviewed Mr. Loyd for 4 or 5 hours. But what I suggest here is the 3 other doctors that have testified at this trial are white. 2 of the state's doctors, Gamache and Werner, and Dr. Mayer. And I'm going to talk about a little bit about Gamache and Werner, but I would suggest to you that one of the things you need to consider is, is he being completely upfront and truthful about everything because he's trying to make himself look less crazy? That's what underreporting is. Let me talk about the state's witnesses. Dr. Gamache is very intelligent. By appearance, he appears to be the know-it-all witness of all times. He never, ever answers the question without giving his opinion about something else. He's always very focused to make himself look good and the state look good. And more importantly, he is someone that you can't really rely on because of who he is and what he is. This is a gentleman, and I know all of you have indicated that you believe in the death penalty, but this is a gentleman who has a business model where he does the defense and the state, and he's done a lot of both. I think he's done like 35, 40 death penalty cases for the state. This is a guy who has told you time and time again things that didn't end up being correct. And I'll give you one example. Facebook. It was painful for you guys to have to listen to 210 pages of questions about Facebook. But Dr. Gamache never thought that would happen. Dr. Gamache's evaluation was videotaped, as was Dr. Warner's. What that allows is a transcript to be created of everything that's talked about between the two of them. It's memorialized. And when you have a situation like that, you can't get away from what was said in the evaluation. And I would suggest to you, in this particular case, he had said, which was the predicate that brought out the Facebook. Oh yeah, I talked about numerous times about the Facebook. And I was like, really? Okay, let's go through this. And I went through 200 and something pages of the interview he had with Mr. Loyd. And Dr. Gamache, being the smooth operator that he is, was all of a sudden like, well, I don't mean I'm talking about using the worst Facebook, but I'm really talking about everything that is in his Facebook pages, which was ridiculous. This is a guy who has spent years and years and years working for law enforcement. He worked for the FDLE, the Hillsborough County Sheriff's Department, the Tampa Sheriff's Department. And why is that important? Because it's something you can consider in terms of his reliability and motivation. I mean, he clearly, and obviously we're all respectful of law enforcement and know how important they are to us. But if you have a witness who's coming in who has a predetermined decision about his relationship because he's pro-law enforcement and then testifying for the state, those are two kind of things that come together that don't seem very safe. And we heard from Dr. Warner. We didn't hear much details from Dr. Warner. I did question her a number of times about what she omitted or was inconsistent with her report and the evaluation she did. And I think one time she got offended. She was laughing, like I was picking at something. Like he had said he was actually 20 when this happened, and she had said 17 or 18. That all becomes important because they want to try to fix in that Mr. Loyd is not being truthful about something. And so they had an opportunity to have both transcripts of Mr. Loyd's interview where he talked about Dixon, where he talked about this event, to use as impeachment against Mr. Loyd. Well, Mr. Loyd, didn't you say this then? Didn't you say that then? And it failed miserably for them because Mr. Loyd never changed his story. Let's talk about Markeith Loyd. Judge, do you know how much time I have left?
You have about 15 minutes left.
15 minutes, thank you. You listen to Markeith Loyd. He did not have to testify. Every individual who's charged with a crime has the absolute right not to testify because he could be cross-examined, they could bring evidence against him, make omissions. Not once did he deny ever shooting and killing Lieutenant Clayton. But he told you the story, which is consistent with the evidence. He ran. He was trying to get away. She came closer. He turned directions. He heard a shot. He turned around. He had his gun. There was a gun battle. She was shooting at him. He was shooting at her. And he stood. He never stood over her and shot her. He stood back. When you look at the video, see when it happens. Watch her arms. It's important for you to evaluate every witness's testimony. And you know in the back of your mind, Mr. Loyd was convicted of murder and doing a life sentence. We know the judge had you promise that you couldn't factor that in. And you shouldn't factor it in. But what you need to factor in is your evaluation of his testimony and what he said, and how it's consistent or inconsistent with the evidence. And I would suggest it's consistent. I would suggest not one time was Mr. Loyd impeached by the prosecution. And although he may be someone that we as a community have issues with, although he may be someone that we can't imagine ever understanding where he came from or what he has experienced, you still have to follow the laws of our state. Okay, I want to talk a little bit about the jury instructions. I don't understand what this is. Okay. Okay. Gotcha. There is an instruction included in the first-degree murder instruction of Lieutenant Clayton as a law officer that talks about heat of passion. And a determination that if you believe Mr. Loyd did not act with a premeditated design to kill, but he acted in the heat of passion based on adequate provocation, then in order to find the defendant did not act with premeditated design to kill because he acted in the heat of passion based on adequate provocation, and then there's a checklist of 5 different things. And of course, this says, as the law, as I told you, if you have a reasonable doubt about whether the defendant acted with a premeditation designed to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of first-degree murder, premeditated murder of a law enforcement officer. So that's included in the jury instructions on the first-degree murder count of Lieutenant Clayton. And if you find that, then you have to decide what you believe that he's guilty of. You may believe he's guilty of second-degree murder. You may feel he's guilty of manslaughter. Whatever you believe the highest charge that's been proven, that's the one you should check. There are a number of lessers to the main charge against Lieutenant Clayton. As I mentioned, there's the second-degree murder of a law enforcement officer. There's manslaughter, there's regular second degree. So there are a number of lessers on every charge, and I'm really interested in talking to you about the charge involving Lieutenant Clayton's death that you can fine for. You can look at and fine for. And as I told you before, unless there's a conviction for a premeditated first-degree murder, and we are going to be done. So whether you find him
Sustained.
whether you find him guilty of second-degree murder or whatever, those are going to be your options. I'm almost done, folks. Okay. Yeah, I wanted to talk to you about one Facebook post that the state introduced. This is one the state had provided to you. In that one, which is from 6/1/2016, if you look at the last sentence, I'd rather die than live my life in cell without a female, so I'm going to do right to stay right. Completely inconsistent with what the state says. Again, I remind you, it is extremely important to view these videos until you are comfortable that you have a firm belief in what is being depicted. And I would strongly suggest that you have this in front of you when you look at the video involving the shooting of Lieutenant Clayton, the one they said was cold-blooded killing, and the one I say was self-defense because she was shooting at him at that time, and where he was positioned and what her body was positioned in. In speaking to my client, he reminded me that there is no way possible to make the shot that they're talking about and be standing over her. After you hear all the evidence, folks, I'm confident that you will find Mr. Loyd not guilty as to the charge of first-degree premeditated murder of a law enforcement. Thank you.
Thank you, Mr. Lenneman. Ladies and gentlemen, do you need a break before the state's rebuttal? All right, why don't you take it's 3:10, why don't you guys take a 15-minute break? When you come back, it'll be the state's rebuttal. I'll finish the jury instructions, and we'll send you out to deliberate. Thank you. All right, anything we need to address? 15 minutes? All right, we're back on the record on State versus Lloyd. Mr. Lloyd's present with his attorney. State Attorney's Office is present. Is the jury ready? All right, let's bring him back in. State recognized presence of the jury.
We do, Your Honor.
Defense? Yes. All right, Mr. Williams, your rebuttal.
Thank you, Your Honor. So facts are stubborn things. And when the facts are contrary to your position, there are times when you end up saying things that can be inconsistent or don't make a lot of sense. And it's been my experience that if you listen long enough and hard enough, that will come. So I wrote down a couple of the arguments that were made to you just to point out that they are inconsistent with the facts. And the first one is perhaps the most significant, which is at one point, Mr. Linneman, in describing the fear that he says his client felt on the morning of January 9th, he said, quote, "This is reasonable person fear, not insanity." And therein lies the problem. You're being asked to believe, to conclude that it's been proven to you that Mr. Lloyd is insane. And yet they're also asking you to find, according to a reasonable person standard, that he was defending himself from Lieutenant Clayton on the morning of January 9th. And of course, those two things are entirely inconsistent. Now, you also heard some other things that I want to address. At one point, counsel said they never wanted to show this to you, referring to the video. You are to rely on your own recollection of the facts, but it's my recollection that we showed the video of this incident in the opening statement of this case. Everything that happened, all the video from outside was shown to you within the first 5 minutes of you sitting in those seats. He could not walk away. That statement was made to you regarding Lloyd's decision to chase Lieutenant Clayton through the parking lot of the Walmart. Is there a gravitational pull in the Walmart that we are unaware of that operates in that parking lot only? Because that's the same thing Mr. Lloyd tried to tell you, that his momentum, remember, quote, that was his word, and I asked him, were you running down a hill? Is there something we should be aware of? And yet you're being told that he couldn't stop. When, of course, we know every day that people who are running come to a stop. They go when they're jogging, they jog, they stop, they walk back to their house. They start to chase after a vehicle, they stop, go back to their house. Their dog runs away from them, they chase, they stop, they go back the other way. And yet you're told that Mr. Lloyd could not stop. Quote, he shot at the wheel. That's not what Markeith Loyd told you he did. Markeith Loyd told you he fired a warning shot into the ground. And we've already talked about how the wheel of the vehicle was several feet away, protecting Captain Carter, who was hiding behind his vehicle when it was shot. On multiple occasions, the murder at 6031 Longpeak Drive in December of 2016 was referred to as the event. It was a murder. It's been established it was a murder. And I warned you that the attacks on us would come, and that it would be suggested, in fact, it was outright told to you that lying, weaselly was the term that was used, with no evidence whatsoever, but it was, we were attacked. because the facts in this case are unimpeachable. So you have to go elsewhere for attacks. A couple of other things that were said that I'm going to address, and I'm not going to go through everything point by point because you all have heard the evidence and been very patient with all of us in this system. The sloppy investigation argument. It was argued to you that there's a conflict of interest with the Orlando Police Department. Detective Cadis had a conflict of interest, and that therefore you shouldn't believe the evidence in this case. What evidence have you heard whatsoever that was subject to any conflict, that had anything to do with a person's subjective belief? The strongest evidence in this case is the video that you saw moments before or moments into the opening statement by the state of Florida. And that was collected less than 30 minutes after Lieutenant Clayton was gunned down. There's no dispute. They are asking you to rely on it. And yet it's being suggested to you that somehow the Orlando Police Department acted inappropriately in their investigation. Again, no evidence of that. And it's just suggestions, thoughts that are put out. And for what purpose, you ask yourself? Because that goes the same thing with this shot and Detective Overfield and the suggestion that there was something wrong about what was done. Detective Overfield found a piece of evidence and did exactly what he's supposed to do. He called to find out how it should be addressed. He was told, he collected it, and then law enforcement sent it to the Florida Department of Law Enforcement on their own. Richard Ruth tested it. And then we presented that evidence to you, unbiased regardless of what the outcome is, because facts are facts. Facts are stubborn things. And the problem for Markeith Loyd is that the facts in this case clearly establish he committed a cold-blooded murder, law enforcement officer. Dr. Gamache, Dr. Mayer, and Dr. Warner are white. Is that to suggest that unless you're an African-American psychiatrist or psychologist, you can never diagnose African-American or find that they're insane? Is that rational based upon our knowledge of science and experience in today's world? The defendant was running into the woods. You have an evidence, photographs from the Walmart. You can all see, you'll have a chance to look clearly where Markeith Loyd ran. He wasn't running through the parking lot. In fact, counsel mentioned that the woods were across the street. He ran to the pillar. And why did he run to the pillar? Because he needed a couple of moments to be able to draw the .40 caliber loaded firearm in his waistband to shoot and kill Lieutenant Debra Clayton. And finally, the heat of passion argument was made to you. So your heat of passion instruction is on page 6 of your jury instructions. And if you just make a cursory glance at the 5 elements that have to be shown in order for you to find that Markeith Loyd acted with a heat of passion, you quickly see that it does not apply in this case. A sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. Does an ordinary reasonable person, when confronted by law enforcement, decide to run and then pull a gun on them? Of course not. Of course not. A reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. Well, again, you're being told that Mr. Loyd was unable to know right from wrong that morning. And while he certainly harbored an anger and hatred towards law enforcement, there's no evidence that he was angry as he was walking out the doors. This instruction is typically used, the example that is used is when a spouse finds his or her spouse in an affair with another individual. When a sudden, unknowing, unprovoked incident occurs and a person has no time to react, and they react because of what they occurred. Folks, Markeith Loyd knew the police were looking for him. He was aware of that for weeks. This was not a surprise to him. He told you how he watched Lieutenant Clayton walk out of the Walmart. He told you that he believes he knew she was a law enforcement officer. This instruction does not apply. Mr. Loyd did not act in a heat of passion. So now we're going to be a little more methodical about how we go through evaluating the defenses that were raised to you. And I'm going to be brief. So there are two reasons why Mr. Loyd says or claims that he should not be held responsible for the murder of this law enforcement officer. The first one is insanity. And the insanity instruction is in front of you. You all heard it. It shows or saw. It shows that it's their burden to prove. And it's important. All persons are presumed to be sane. All persons are presumed to be sane. Clear and convincing evidence. So what is the evidence that they presented to you as to Mr. Loyd's insanity? The first, which was not mentioned in the closing argument, was his family members. And you heard Ms. Loyd, Tanya Loyd, get up, and you heard Barry Jacobs testify about their observations of Mr. Loyd. It is understandable to look out for your loved one, and they can be forgiven. However, that does not mean they can be believed. Specifically, Ms. Loyd, who is not a trained psychiatrist or psychologist, told you that he was foaming at the mouth, and Dr. Gamache clearly said that that is not any indication of psychosis that he's aware of, and he gave you the examples of when he would expect to see that. The other reason that you know you cannot rely upon the defendant's family members is found at page 49 of your instructions, and it's a list that's called Weighing the Evidence. And the fourth number on that list is, did the witness have some interest in how the case should be decided? And as I told you, while we can appreciate the reason why family members might want to shade the truth for their loved ones, it is a factor that you must consider strongly when considering their testimony. So that brings us to Dr. Toomer, who is the primary source of the defense evidence of insanity in this case. And there are three things I would ask you to look for: his lack of credibility, his lack of detail, and his lack of care. So number one, his lack of credibility. Again, I told you in the opening statement of this case who Dr. Toomer was, and his testimony confirmed that. He told you about the money that he made and makes as a defense witness. He told you he has a moral objection to the death penalty, and he told you that he only testifies in capital cases for the defense. Check, check, check. He acknowledged all of those points. But then he went a step further when he tried to, I would argue to you, mislead you as to where his actual expertise is. Because if you recall, the questions were, well, I'm a doctor, I practice forensic psychology, I'm board certified, didn't mention any of the details behind that. Because what you actually heard is his doctorate is in social and group processes, not in forensic psychology. You also heard that he's board certified in organizational and business consulting. So if there becomes an occasion where we need an expert to organize a business, we will certainly call Dr. Toomer. But you should consider his area of expertise and his board certification when it comes to whether or not you can trust his testimony as to whether Mr. Loyd was insane at the time of this offense. And more importantly, it should give you great concern about Dr. Toomer's credibility and his willingness to be truthful and honest with all of you about his findings. So that's a lack of credibility, a lack of detail. He did not tell you, really, why he thinks Markeith Loyd is insane. He hardly described what insane under the law was. If you recall, he started talking about mental illness and symptoms, and then somewhere in the middle of his testimony, he tried to say that there are two prongs of an insanity defense, and then at the very end of his testimony, he said that Mr. Loyd did not know what he was doing was wrong, with no explanation whatsoever. Did not address the fact that Mr. Loyd ran from the scene, indicating that he knew what he had done was wrong. Did not address any of the facts that were inconsistent with his hypothesis, just made a blanket statement and moved on. What he did was repeat phrases like totality and pathology and circumstances over and over again. Whenever a question was asked or a question that he was not comfortable answering, I would submit to you that was his go-to. But he's not to be blamed because he's a board certified in organizational processes, organizational consulting. And even though, yes, he repeated what Mr. Loyd told him about the events of the murder, he never explained how that had anything to do or how it informed his opinion that Mr. Loyd didn't know his killing of Debra Clayton was wrong. So then the final thing is a lack of care. Because the other watchword, the third watchword from Dr. Toomer was data, right? He was constantly referring to the data in the case. And he told you he relied upon the findings of several other experts in the case. Dr. Joseph Sesta, Dr. Mayer was another one, Dr. Campbell was another one. And he told you that his finding of neurological impairment, brain damage, was based on Dr. Sesta's report. And then he had to acknowledge that Dr. Sesta found that there was no long-lasting neurological trauma. And even if there had been, it did not affect Mr. Loyd's behavior. He told you he adopted these people's findings, including Dr. Mayer, who found Mr. Loyd was not insane in December of 2016. So when did that insanity develop? Because Dr. Toomer was very clear with all of you that he believes Mr. Loyd has been mentally ill for many, many years and months. Completely inconsistent with the testimony of Dr. Mayer. So I am not, to be clear, suggesting that Dr. Toomer lied about this. I am suggesting and telling you that he was sloppy. That he didn't actually read the things closely that he said he relied upon. And the reason for that is simple. Dr. Toomer knew the outcome he wanted to reach before he began to do the work in this case. So we looked at some reports. He used the word culture a lot, and eventually he was able to give you the opinion that ultimately he wanted to reach from the beginning. And the final evidence of insanity from the defense was Mr. Loyd himself. Now, Mr. Loyd was on the stand for nearly 3 hours. And I would argue to you what you observed was an intelligent, thoughtful individual. He's got beliefs that most people don't. He's strong in his beliefs, but nothing about what Mr. Loyd said was irrational. The defense would like you to believe that it is irrational for him to believe that racism exists in this country. Of course racism exists in this country. It's just that Mr. Loyd wants to kill police officers because of it. That is not insanity. Mr. Loyd testified, and I would submit to you, as we discussed earlier, that he has used his time and his intelligence to make sure that the facts that he read in the discovery fit his testimony. And as he went through, he did the obvious. He admitted what he could not deny, and he denied whatever he could not admit. When it was clearly on video, he went along with it. But if there was another explanation, that's what he found, and that's what he gave you. So as to insanity, we presented witnesses to you on the issue of insanity. And I agree with counsel that Dr. Gamache is a very intelligent individual. And I'm not going to recount all of his testimony, but I would submit to you that his expertise and testimony spoke for itself. He was very clear that he found no mental illness with Mr. Loyd, and he gave you the reasons why. There is no impairment that he demonstrated, and that's another thing that Mr. Loyd's testimony made very clear. He was operating at a very high level, a level most people cannot, working 4 jobs at one time, keeping a social life. And therefore, he does not have a cognizable mental illness. What was also really interesting about Dr. Gamache's testimony was how it completely destroyed the concept that he had not looked. Because Dr. Gamache took a deep dive on culture and looked at the actual evidence in the case, and how Mr. Loyd has adopted parts of subculture which makes his delusion not a delusion, but a simple belief that other people may not share, but it's part of his subculture. Not to mention that Dr. Toomer would have you believe that Markeith Loyd's delusion was that police were out to get him on January 9th of 2017. Of course they were out to get him. He had a warrant for first-degree murder. Finally, Dr. Werner testified, and she was brief. We kept it brief because she has zero bias. She is a clinician who works in a hospital 7 days a week. She experiences and interacts with and treats people of lower socioeconomic backgrounds of all races every single day. The idea that she doesn't understand culture and the impact that it has on the people that she sees is farcical. She doesn't even get paid for her work. She gets no extra benefit for coming in here and telling you her opinion. And what was her opinion? Mr. Loyd has antisocial personality disorder. He disobeys the laws, but he's not mentally ill. And he certainly was capable of knowing the consequences of his actions and right from wrong on January 9th of 2017. Now, I want to take a moment to acknowledge that racism is real. And it is obviously an undercurrent of this entire conversation in the trial that is going on, and it's particularly important to Mr. Loyd. And I don't want anyone to believe that we do not believe that it is a real thing in this country. Perhaps it's less real now than it was 50 years ago or 20 years ago, but we recognize that there are far too many black men and women who have been shot and killed by law enforcement officers in this country. That is a fact that is unimpeachable, and we're telling you this. I am telling you this. We recognize that Mr. Loyd had a difficult childhood and that he did not have opportunities that other people had. I don't think there's a question about that. The issue, ladies and gentlemen, is what that had to do with his actions on January 9th of 2017. There is zero evidence that any of those unfortunate facts and the realities that we all see every day had anything to do with him standing over a police officer and killing her. Markeith Loyd shot Lieutenant Clayton because he wanted to get away. It's that simple. So the last topic is self-defense. So the first thing to note, and the relevant instructions are on pages 44 and 46 of the printed copies that you all have. I'm not going to read it to you because you're adults, but the first part defines, most importantly, that there is a specific standard that is used when a law enforcement officer is using force. It's laid out on the screen in front of you. It's on page 44 of your instructions. Reasonably believes necessary to defend herself or another from bodily harm. That is the standard. In arresting a felon who is fleeing from justice, which is exactly what Mr. Loyd was on January 9th of 2017. It even tells you below that firing a firearm in the direction of a person, yes, it's deadly force. Is it reasonable based upon the circumstances that were confronting her today? But this is not the only relevant instruction. So if you flip over then to page 45, which is 3.6F, the second paragraph, which is what is on the screen, is really the two-step process that you have to evaluate when it comes to self-defense in this case. The first thing is, unless it is you conclude that Officer or Lieutenant Clayton used excessive force, the conversation is done. If her force was reasonable at the time, then he did not act in self-defense. That is the law in the state of Florida. If you were to find that Lieutenant Clayton used excessive force, then he would only be justified in the use of reasonable force to defend himself. So what we're going to do for the last couple of minutes that I speak to you is talk about the contrasting uses of force that you've heard evidence about. So we're going to start with Lieutenant Clayton's use of force, and more specifically, the knowledge that she had as she approached Mr. Loyd that morning. So we know that Lieutenant Clayton knew she was confronting an exceptionally dangerous situation. We know that because Takesha Bryant told you that when she ran out of the Walmart, she went and she told Lieutenant Clayton that there was a man in the Walmart wanted for murder and specifically for shooting a pregnant female. Those were the circumstances confronting Lieutenant Clayton. But we know that she knew that not just because Ms. Bryant told you, but because that is what she told on the radio.
Probably 20. Hey, give me a clear channel at Walmart. Give me a couple of units worth of signal 17 if possible, signal 5 suspect.
She requested a clear channel, indicating a potential
1033 traffic on emergency north, Revolver 20 out at the Walmart, 3101 West Princeton Street, reference attempted contact, possible signal 5 suspect, 1033 on emergency north.
signal 5 murder suspect.
25 Alpha, we broke, we're here. Bravo, 26 officer.
Yeah.
Sarge, where are you exactly?
I guess we're looking for Markeith. He's walking out the door right now. I guess he was involved in shooting with a pregnant female. I'm at the first entrance.
Not just the shooting of a pregnant female. You know it because Ms. Bryant told you. You know it because she said it on the radio. It's hard to imagine a more perilous situation for Lieutenant Clayton to confront. And as I told you during the first closing statement where I addressed you, she did everything right. She called for help. She slowly walked over to the door. Other than letting a known murderer leave, putting others at peril, what was she to do? So now we know what she knew at the time. I left out one thing. There's evidence that she knew he was wearing a vest. Because you recall Takesha Bryant knew that, and she was not a trained 20-year law enforcement. And we know that Lieutenant Clayton watched as Mr. Loyd exited out of the store. We know that from Takesha Bryant, Julia Johnson, and Monica Pridgeon that she gave Markeith Loyd lawful commands before ever doing anything in this case. We know she saw Markeith Loyd run and not surrender. And we know she likely saw the defendant pulling out his gun before he got to the first hole. I'm not going to go back and forth and argue with you over the video. You have eyes, you're adults. If you want to watch the video over and over again, watch the video. And we're confident that you're going to see what's been described by the state. We know that because he kept it on his right side, and that's the side that he ran around the pole. So even if we assume that Lieutenant Clayton fired as Mr. Loyd rounded that pole, that was not excessive force given the circumstances that she was confronted with. I would also submit to you that there is very little evidence that she fired at all. Now, here again, recall what I told you in the opening statement. I was upfront and candid with you that we cannot prove definitively whether or not she fired or who fired first. But there is strong evidence suggesting that she never fired at Markeith Loyd. So how do we know that? I'm not going to belabor the point. but I do want you to see it one more time. And in fact, defense counsel and I are in agreement on this. So if you can see her arm extended in that video, more power to you. I would submit to you that it's entirely unclear based upon the video quality that we have. Mr. Loyd now turns and starts to chase Lieutenant Clayton. And we're coming up to the most important part, and I'll try to slow it down enough. Right there. You see the cloud of dust or smoke come up from Lieutenant Clayton, where in all likelihood, as she runs away with the firearm, her firearm in her right hand, she shoots down at the ground. Now, why is that important? Because there was agreement, including with the defense expert, Mr. Robinson, that the firearms collected, including her 6.226, eject to the right, 45-degree angle, right? So it's pretty clear if she's running away and the firearm is pointing down at a normal angle, it's going to go to the right. That's where the shell casing will go. The only 9mm shell casing found anywhere other than where she's sitting is right here, which is entirely consistent with her discharge of the firearm at the ground. If she had discharged her firearm anywhere up here, we would expect to see the shell casing in this area. Not to mention, the locations don't match, there's only one. We know she fired one shot into the ground. It's on video, there's no doubt about it. I told you that. There was one of her shell casings, and you subtly heard the explanation. Well, there's the missing shell casing. Is there? Or is the obvious answer that she didn't fire at Mr. Loyd? Because the only evidence that she did fire is completely inconclusive as to anything. There's a ricochet that may or may not be caused by a projectile. There's a projectile that may or may not be fired by the gun. What you know with your own eyes is that she fired once in the shell casing. One shell casing is where it should be. If that's the only shot that she fired. So while we would argue to you that Lieutenant Clayton was completely within her right, based upon the facts confronting her that morning to fire at Mr. Loyd, that it's beyond clear that she ever did that. And much more likely based upon the evidence that Mr. Loyd fired at her first. I would submit to you further that if Lieutenant Clayton's firing at Mr. Loyd under those circumstances is unreasonable or unlawful, then no dangerous individual can ever be taken into custody. Because the unfortunate reality is we saw what happens in a situation where law enforcement confronts a dangerous individual who does not want to go with them. She did everything right. And even if she discharged her firearm trying to bring him into custody, she was unable to save her life. Under that standard, law enforcement can never make an arrest of a person who is dangerous and wanted for a dangerous crime.
Overruled.
So that brings us to the other side of the coin, which is Mr. Loyd's use of force. Because even if you find that her use of force was excessive, you would have to find that his was reasonable under the circumstances. Mr. Loyd knew he was not lawfully permitted to hold a firearm or to have a gun, and yet that's what he had. Assuming she fired at him and he was fearful, at any point he could have gotten on the ground and surrendered. You know, as a matter of as a matter of reasonable experience, that when people shoot guns, you duck. You know that from the evidence in this case, because Takesha Bryant told you when the gunshot started, what did she do? She got down. In the remainder of the video that you're going to see, there's an individual in the parking lot out when the gunshots start. What does he do? He starts to run away, he jumps to the ground. If you're surprised or in fear of a firearm and being shot, you do not run around and chase after the individual. At the moment on the screen in front of you, right there, his use of force must end under the law. Is it reasonable at that point for him to continue firing at an individual who is running away? Let's leave law enforcement out of it for a moment. Under what circumstances can a person chase another human being and shoot them in the back and say that that is a reasonable use of force? Yet that is exactly what you're being asked to accept. But of course, ladies and gentlemen, Mr. Loyd did not stop when she was running away. He put himself in harm's way, going closer to her near the firearm, purposefully to end her life. Now, Mr. Loyd made a big deal in his testimony, and it was argued to you about the killing of African-American men and women by law enforcement. But what you know is that Markeith Loyd was not 12-year-old Tamir Rice with a toy gun in that video. He was not Ahmaud Arbery running through a neighborhood just out for a jog and killed by vigilantes. And he was not George Floyd unarmed and wanted because he counterfeited a $20 bill. That is what the strong, if not overt suggestion to you has been throughout the course of this trial. And it is just not the facts that you are confronted with in this case. He was a man armed and wanted for murder. There was no fear, there was no self-defense, there was only murder. And nothing about the video that you have seen indicates otherwise. We all make choices in this life. Debra Clayton was a black female police officer. She chose to serve. And the evidence is that on the morning of January 9th, 2017, she chose bravery. She chose to uphold her oath to protect the citizens of this community. She went towards the danger, and she is dead because Markeith Loyd valued his freedom more than her life. Markeith Loyd chose to violate the law. He chose anger. He chose aggression. He chose to evade police. He chose to carry a loaded .40 caliber firearm, to don a bulletproof vest, to shoot at a law enforcement officer running away from him, and to stand over her and end her life. The time has come, ladies and gentlemen, where we ask you to hold Markeith Loyd responsible for his choices. And we ask that you find him guilty as charged in this case. Thank you.
Thank you, Mr. Williams. All right, ladies and gentlemen, both sides have now concluded their closing arguments. So if you'll turn to page 52, if you're following along on the jury instructions.
Got it.
Really? Okay. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. If y'all will look at your screens, the attorneys have agreed to help me out with this, and I appreciate everybody's help. There are multiple verdict forms in this case because of the multiple counts in the special findings. So, for example, this would be the verdict for count 1. You'll see that it starts with, we the jury find as follows as to count 1 of the charge. Check only 1 as to this count. It starts with the charge as charged on the indictment, and then the rest of it are the lesser includeds. In this case, you're going to have guilty of first-degree murder of a law enforcement officer, guilty of first-degree murder, guilty of second-degree murder of a law enforcement officer, guilty of second-degree murder, guilty of manslaughter. The defendant is not guilty by reason of insanity, or the defendant is not guilty. You can only reach one verdict. You can't check all of them. You have to pick whichever the highest one is that's been proven, or if none have been proven, not guilty, or not guilty by reason of insanity. Those are your options. Whoever the foreperson is, you must sign and date this form. If you don't sign and date the form, I have to send you back so that you can, sign and date the form, okay? So, next up will be, and you'll see this for each of the counts. We're going to go through this quickly, but there's a special finding form for count 1, and this is the firearm question that I read you the instruction on. So if you find the defendant guilty of first-degree murder of a law enforcement officer, first-degree murder, second-degree murder of a law enforcement officer, or second-degree murder, then you have to answer one of these questions. Now, this one, you have to answer all the questions, all right? So, 1, during the commission of the offense, did the defendant actually possess a firearm? You pick yes or no. Then 2, during the commission of the offense, did the defendant personally discharge a firearm? Yes or no. 3, during the commission of the offense and as a result of the discharge of the firearm, was death caused to Debra Clayton? Yes or no. Sign and date this form, all right? Next up, we have the verdict, the special finding. If you find the defendant guilty of manslaughter, this is still count 1. There's one question on that one, which is during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Answer yes or no, check, date it and sign it, okay? This is the verdict as to count 2. I'm not going to read all of it to you, but again, you've got to pick one. It starts with the charged in the indictment and works its way down, okay? Date and sign the form. Count 2 has the special findings concerning firearms. Again, you need to answer both questions. And It's as to, there's a separate special finding as to attempted manslaughter by act because it has only one question that has to be answered, if that's what you convict him of. Count 3, you pick one. He's first charge aggravated assault, improper exhibition of a firearm, guilty of assault, or not guilty. Sign in every one of them, you've got to sign and date them. Count 4, if I'm going too fast, let me know. Same thing, all right? You starting to catch on what these verdict forms look like? All right. There's a special finding as to the verdict form for count 4. Again, it's the firearm special finding. And that applies to grand theft also, which is one of the lessers. Count 5, there's just 2 choices, guilty or not guilty. That's possession of firearm by a convicted felon. And it also has the special firearm finding if you find him guilty. All right. All right. Thank you very much. I'm going to send these verdict forms back into the jury room when you all retire. All right. I'll send one set back. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communications such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send a note through the court deputy, signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Some exhibits will be sent into the jury room with you when you begin to deliberate. If you need to see other exhibits or a video played, they will be provided upon request. Did you all bring the white laptop? No. All right. So going back into the jury room with you is a completely blank laptop that you can use to play the videos introduced by both the state and the defense, all right? So you can view those at your leisure in the jury room. If you have any problems, let us know immediately. Don't try to unjam it, especially with the video or the thumb drive in there, okay? In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Any other instructions requested by state? No, Your Honor. Defense? All right. All right, folks. You're going to take with you your notepads, your jury instructions. The following jurors are to remain in the courtroom. The rest of you may retire. Juror number 294, juror number 2000, juror number 367, juror number 30, juror number 474, and juror number 2191. You stay in the courtroom, everyone else retire. We'll send the exhibits and that back in a minute. We've got to gather all this. It's going to take us a few minutes, folks, all right? Got it? Yeah. Yeah, let me have this one. These are the instructions as read that can be filed. That's the verdict forms going back to the jury room. All right. I bet you've all guessed. You're the alternates in this case. But because the type of case this is, because it's a capital case, while we normally dismiss the alternates at this point, we cannot dismiss you at this point. If this jury finds Mr. Loyd guilty of first-degree murder, there has to be a penalty phase, and you have to be part of the penalty phase in case one of those jurors gets sick. You would then step in, and I don't seat the jurors in order in case you hadn't figured that out yet. You would then have to step in to substitute for one of them during the penalty phase. So that means, unfortunately, we have to keep you in sequestration until this verdict is reached, and I'll have further instructions for you. The other thing that's going to happen is if this jury does not reach a verdict today, you can't have any contact with them until they do. So the deputies are going to separate you all at the hotel. These are all things that are unique to capital cases. You all have been paying very close attention. I've been watching you all, taking notes. So the good news for you is that your day has ended and you're going back to the hotel to have a nice dinner and relax while your fellow jurors work on a verdict here. All right? Have a good evening. Does anybody have any questions? Yes, sir. You can leave your notepads and those jury instructions here with us. They're still going to be sealed up. They're not going to be destroyed at this point. All right? Just leave them on your seats. Any other questions? All right. If you'll follow the deputies, they're going to get everything you need out of the jury room for you, but if you'll follow them, have a good evening, folks. All right, at some point during the closings, was it after the defense closing? I think so. After the defense closing, a juror wrote a question. And the question is DSM-5 in evidence? I've answered the question, and my answer is it is not, and I've signed my name. So if the attorneys want to come up here and see this, I'm going to send it back to them since they asked. So if you all want to see what the question and my answer looks like, then that will be made part of the record. All right, if the attorneys will please come check the exhibits that are going back into the jury room and make sure that nothing that's going back, that there's nothing that's not in evidence going back. The firearms will remain in the courtroom. Defense, have you checked the laptop, the wiped laptop? Is that a yes, a no, or maybe? Wiped. Have you checked the wiped laptop? You checked it, Ms. O'Shea? All right, we're good?
In regards to that question,
What question?
about the DSM-5,
Yes.
Mr. Loyd has a comment.
You want me to say it? You want to say it? You never get that right.
Can we get to his, we got to get this stuff back there. It's not in evidence. Mr. Loyd, I'm going to let you, I'm going to talk to you about any comments that you have about the trial in just a minute. But right now, I need to go through these exhibits and get this back to the jury, and then you can say.
I know, but before they go back to the jury, that's what this is about.
He's talking about the note, Judge.
About the question about the DSM-5, it's not in evidence.
Explain to what I'm saying.
He's saying that the jury should know that the DSM-5 discussions amongst the experts what isn't evidence. He wants you to write that.
But they
That
dis-
request is denied.
but they
The
disregard.
jury question has been answered. The DSM-5 is not in evidence.
Just put it on record.
They disregard the evidence, Judge.
I'm sorry?
My client wanted me to add that you should write it, what I just requested, before they disregard the evidence.
All right, I've heard your client's request. It's denied. All right, let's get these exhibits and that laptop back to him. So take a few minutes and make sure that what's going back is what's in evidence. Where are the ones that were not admitted? Yes, we're going to pull out the buggy that contains the evidence that was not admitted so that you can make sure there's nothing in there that was admitted.
There is a password in the bottom left. It's not sticky. Bottom left of the laptop. I don't know if you want to tell the jurors that the password is there and log in.
Okay.
Yeah. Oh, okay, good.
I've shown the laptop to the defense, Your Honor. They've agreed it's clean. There's nothing on it.
All right, great.
Again, the password in the bottom left, there's an attachment that you have to plug the USB drive or an external CD player if you want to play the CDs
All right,
into the adapter.
where'd Claire go? We're going to have you explain that to the deputy who talks to the jury and let her tell them. You'll do it? All right. Officer Davis is going to handle it.
Sorry? Yes.
Your Honor, the state's reviewed all the evidence, and it's acceptable to go back to the jury.
Defense? All right. I think that's it then. Court's in recess pending the verdict of the jury.
Just give me a few minutes, let me get this back.
No problem. And I'll need to see the attorneys on a scheduling issue, please.
Stuff I'm telling them finna happen and stuff I'm telling them to do, they don't do it, and then the prosecution go right up there and do the stuff I tell them what they finna do. These people slow as fuck. They slow and they not listening. They don't know shit.
Do you have
All they
any?
doing is they're lying.
All right, stop cursing. And what are your specific objections?
This is one of the things I told them to do.
All right.
Before the opening, I told them, I said, bring this, do this, because they're finna do this, because he set up there, Ryan Williams set up there and lied and told the jury, oh, Markeith Loyd, he looked at evidence and he came and made up a story because Antoine Thomas said, are you serious? He seen that, he looked at the evidence, he made up a story. But now, this says, before I present the case, Markeith want me to point something out to the jury while it's fresh. The state just told you Markeith studied evidence to make up a story about Antoine or anything else. Remember, Antoine testified and he said to Markeith, "Are you serious?" Well, Markeith didn't have because Markeith didn't have the gun pointed at him, as he say. Because if someone has guns pointed in your face and you're scared, of course you're going to know they're serious. The prosecution just put forward to you that Markeith got the statement from evidence and used it in his testimony to you. The prosecution will continue to mislead and interpret things the way they want it to be. Jurors, think for yourself. Jury, do you remember when Antoine testified and he said to Markeith, "Are you serious?" And I gave, which he would have been speaking, and I gave Antoine his statement, and I told him, show me in your statement where you made that statement, "Are you serious?" And he couldn't find that in his statement, and he said, I quote, "I said it, I guess the police didn't put it in them." So how could Markeith have studied evidence and got that statement out of the evidence that was never in evidence? Pay close attention. They will continue to not tell the truth and change stories all the way down to the last shot of Clayton. You will see, and I guess they'll change that. They'll change that when they come up, because you could never stand over no one and make the bullet path that the trajectory goes from her neck. If I was still a score over here and made that shot, it was impossible to make that bullet path. And I knew they was going to come up and tell these lies, but all they've been doing is lying. He's not listening. They don't listen. They think they're intelligent, and they think they know everything when they don't.
So is this something that you wanted your attorneys to say?
Yes, I told him before he started his closing, to say this, because I knew they was going to come up there and say this, because they lied to the jury and said, "Oh, he got this out of evidence. Are you serious?" From evidence being made up a story. It's not in evidence, Judge.
All right. So is there anything else that you asked your attorneys to say?
It's a bunch of stuff. It's a bunch of stuff.
Do you want to list it now?
No, because I'm upset right now, and I'm about to can't even talk no more.
All right.
Because they don't fucking they think they know everything.
Mr. Loyd, watch
slow.
your language. Take a deep breath and calm down.
They slow as fuck. They think they're so smart, but they're not. You're not more intelligent than me.
Is there any, other than the
Them or them.
Mr. Loyd,
Y'all slow.
focus. Mr. Loyd, you need to look at me and focus. Take a deep breath and calm down. Is there, other than the witnesses you've listed in various motions that you wanted to call, are there any other witnesses that you asked your attorneys to call during the trial that they did not call?
Yes, plenty, yes.
Who are those witnesses?
Matt Quitter, Chuck Ashworth that they got up there, them, a bunch of law enforcement officers. I told them to subpoena my niece and other witnesses.
Do you know their names?
I gave them all the law enforcement officers. And the reason
I listed it, Judge.
And the reason why I told,
Hold on. You listed it in what, Mr. Lenneman?
In the discovery, I listed all the officers that he wanted us to call.
Is that filed in the court file?
It is.
Okay. Go ahead, Mr. Loyd.
And the reason why I wanted those officers listed, because as Savelli them was setting me up from the first case, and they reported the lies to the news that I came over here, bammed on these people's door, and gunned these people down, which the court and them and everybody know that was a complete lie. And that was a trigger for whatever the mental thing they got going on. So now they wanted to leave that out, and that's the main piece of evidence. That was a trigger. You call it a trigger or a stressor. So now, doing the thing, I talked to my niece with the investigator, told them I would turn myself in if they show me they give me some kind of good faith. They not trying to kill me, because in my mind right now they are trying to kill me. So now, during the FDLE investigation, I'm going through the thing. It's a lot of officers. I couldn't believe it. There's a lot of officers that told the truth, that they beat me. They beat me while I had cuffs on. I never resisted, and all this. So I'm like, damn, this was wrong with the system. Now, it was some good officers that tried to be, but you ain't gonna never hear about them because what FDLE do, they responsible for taking up for the bad officer. So now they go discard the good officers, so you never hear about them. So now it's like all officers bad. Cause you mean to tell me that ain't nobody seen nothing? Ain't nobody saying nothing? They say see something, say something, but ain't no officers never seeing nothing. And it was. I'm like, whoa, shit surprised me. So in these same officers during the FDL investigation, this the question of Stacey Salmon was answering them to try to cover for the officers. During your apprehension of Mr. Loyd, is there any evidence to make you think that he would be dangerous so they can fuck me up? Trying to get
Mr. Loyd, stop cursing.
That's why I'm.
Right. I'm happy to listen to you, but you need to follow the rules of the court.
So now, is there any kind of like he was wanted for murder? You know, he had a vest, he had guns, and this and that. So she was naming all these things for them to say, oh yes. So yeah, we got that. Then we heard like you said, those things, and he was going out suicide by
So
car.
you wanted all these witnesses called?
No, I'm telling you this is why I wanted them called.
Oh, okay, go ahead, sure.
So he was going out suicide by car, and this and that. So they was getting all this intel of our suicide by cop and all the which none of this stuff is true. But intel is important. You can get any officer on this stand and ask them, is intel important? They're going to tell you, yeah, intel important. So now you got an alleged murderer wanted. So now, but no officers that's looking for me, which I feel like everyone should have known, every officer in Orange County, every officer in OPD, and every officer that was looking for me. These investigators know I had this belief that they were trying to kill me. And you mean to tell me you didn't tell any of your comrades this? So now, if they would have had this information, this arson could have been avoided. If they would have even just told the truth, it could have been, if they would have even told the truth, I could have been in the county jail. But they would set me up and trying to kill me and tell me, oh, we're not responding for the newspaper. But the whole time, you get the news advisors for Orange County Sheriff's Department, that's what they reported. I came to this house, banged on their door, and gunned these people down. They have the statement, so they know it's a lie. So now they don't want to tell anyone about this because they will be exposed for reporting these lies, and they don't tell no officers that I'm out here with this belief that the police trying to kill me. So they put Debra in danger, and any other officer, and me, and anyone else. So now you're jumping out of bushes. What you think is going to happen? I ain't never wanted to do that. I was trying to turn myself in.
So
and
this is what
none of these people know that I was out here with this belief, but these investigators knew this and told.
So this is
no.
what you wanted these witnesses called for?
Yes.
Any other witnesses you wanted to call for a different reason?
They said they couldn't find the other witnesses. I wanted my niece subpoenaed because she's scared because they're arrested already for nothing.
Okay.
But I wanted her subpoenaed.
Anyone else?
I don't know. My mind got them. It's digressed right now. It fades. I can't.
All right. Mr. Lennon, is there anything you care to put on the record in response?
I'm sorry?
Is there anything you care to put on the record in response to Mr. Loyd's statements? All right.
Judge, I would just specifically in regard to Mr. Loyd's niece that I was in contact with her. She asked me to contact her lawyer, and I spoke to her lawyer. Her name is Gary Rentz, and Ms. Rentz emailed me that Ms. Loyd did not want to testify.
All right. All right. Thank you very much, folks. We're in recess. Thank you, Mr. Loyd. All right, we're back on the record on State versus Lloyd. He's present with his attorney. State Attorney's Office is present. I have a series of questions from the jury. Question number one. Actually, can we have transcripts of witness testimony? No. I mean, that's a standard answer. So, State, anything else?
No, Your Honor.
Defense? No. Okay. On this same page, there is a second question. Can we have a summary list of all evidence? There does exist a summary list, but it's got a lot of detail on it that I'm not willing to give to the jury. Y'all can come look at it if you want. Yeah. Does anyone want me to tell them that they can have testimony read back if they choose? Oh, that's the state's copy? Where's our copy? I'm sorry, I grabbed the wrong copy. Yeah. Oh, no, this has got all kinds of, right. Yeah, this is the clerk's copy. Yeah, it has descriptions of the evidence. I mean, y'all can look at it, but, all right, let me go back to the transcript thing for a minute. Does anybody want me to tell them that they can ask for a readback? Yes. Yeah, I think I have to. So. So my answer is going to be no, but if you need testimony read back, let us know. Please request is all I'm going to say. I don't think we have a summary list that we can give them. All the lists have descriptions of the evidence, which is not evidence. You know, description of what it is or shows. So I think all we can tell them is we do not have a summary list.
I'm sorry, I don't know how to list it, but is there a way to white out the description of the item?
No, we'd have to recreate the entire list. There's close to 100 exhibits in. What? Yeah, that all has to be turned into evidence to check against. You can, sure.
Here's our position, Judge. Our position is that
Where's the question? Oh, I have the question here. Never mind. Go ahead. Yeah.
our position is that there are a couple of things that definitely might it out. Anti-law enforcement sentiment, other items, legal, respectfully ask the court to modify those things that don't go in. I think the descriptions are
State. I haven't looked at, let me see your list, Teresa, please. Thank you. Go ahead.
We don't object, Judge.
Well, here's what's going to happen, which is you all are going to go through this and agree. First of all, we need to make a copy of this. The original is not going back there. And then you all, the clerks are not going to do this. All right, you all, are the two parties are going to have to agree on what is being whited out. All right?
Yes, Your Honor.
So what I'm going to answer is, do we have a summary list of all the evidence? I'm just going to say we're getting one. Okay? We're getting one together. Okay? Or we are getting you one.
No objection, Your Honor.
Okay. All right, that takes care of these two. All right. This one says, do we answer all the specials? Specials is in quotes, because we are assuming that all the lesser charges are included in the highest charge. It took me a minute to decipher this. I think what they're asking me is, if we convict of the highest charge, do we still have to answer the specials, the firearm questions as to the lessers? My answer to this would be only answer the specials, answer the specials as to the charge you convict on, or something to that effect. If you read it, it makes more sense. It took me a minute to figure it out. Teresa. Okay, so I'll go with you. All right. So the answer is going to be, let me write this one out separately before I give it to them. You only need to answer the specials. I'm going to mirror their question, to answer all the specials for the specific charge you convict on. Everybody okay for that, with that? Yes. Let me read it to myself again. I'm just, to make it proper, I'm just going to say you convict, dear God, you convict on, yeah. On or of. You can't end with of, on. You only need to answer the specials for the specific charge you convict of. Okay. All right, and this one, is we can't find the thumb drive from the defense that the lawyer wanted us to look through. That's Q7, and it went back. Did you all put it in? All right, so I'm going to say it's Q7, yellow envelope that says thumbnail. Okay? All right. Okay, here are the 3 sheets. Check the answers. Make sure there's no objections before we send them back. No, there is not. None that's been delivered yet.
My client's asking you to put something on the record.
I'm sorry, what?
My client's asking you to put something on the record.
Okay, hold on, let me finish this. All right. I'm going to wait a few minutes in case they come back and tell me again they can't find the thumbnail. All right, go ahead.
I'm moving for mistrial due to prosecutorial misconduct during closing, where Ryan Williams lied to the jury and misrepresented to the jury that my client was well told the evidence and structured his testimony to the evidence, and Mr. Ryan even referenced some evidence that my client that my client looked over and structured his testimony to that evidence that was never in evidence.
State, you wish to respond?
We'd ask the court to deny the motion, Judge.
I'm sorry?
We'd ask the court to deny the motion.
Motion denied. All right.
Yes, so it's clear this about the Antoine's testimony. What was talked about.
Okay.
What Mr. Lewis
All right.
and the Antoine.
Motion is denied. Anything else, folks? All right, let's be at ease for a few minutes, waiting to see if the jury has any follow-ups to the questions they just asked me. No, that's a good suggestion. All right, that's a good suggestion. So you all, there you go, agree on what you're whiting out. Once that's done, we'll make a copy of it and send the copy back to the jury. Is that another note? What are you making copies of? Oh, the printed ones? Yeah. Okay. I assume this is, someone can do this. What time does she need to take this?
They're good, they found it.
I take it none of you have whiteout? Sure, do you have whiteout? And don't you regret it now, Mr. Williams? Don't you regret that now, Mr. Williams? see what you got.
For other purposes, we removed or whited out any exhibit that was not admitted in
Okay.
evidence. And then the only other whiteout was as to the Facebook records. The words anti-law enforcement center were removed from the description. And I believe there's agreement that the state agrees those are as acceptable and copied and sent back to the
Mr. Lenneman, any objections to this?
Objection.
All right, plus this one. All right, so we need to make a copy of this so that the original can go in the court file and the copy can go to the jury. We need one copy of that. That original goes in the court file as what was sent to the jury. And then the copy goes back to the jury. We have to have a record of what we sent them. And we have another note? Yes. All right, the jury wants a readback of the following: Captain Carter, Karen Livengood, and Markeith Loyd, all in reference to count 2. Madam Court Reporter, how long is it going to take you all to get that together? They want Captain Carter. I would say it would be his entire testimony because it says all in reference to count 2. So Captain Carter, Karen Livengood when she was testifying as to count 2, and Markeith Loyd when he testified as to count 2. So you would need directs and crosses on those things. And I'm going to need to pull the readback instruction. They're asking for. Does anybody remember when, how about the court reporter here, when Karen Livengood testified as to the scene of count 2, Captain Carter, the attempted murder of a law enforcement officer?
It would have been at the end of her first direct and at the end of her second direct. At the end of her first direct, my recollection is she testified about processing the scene in photographs.
Okay.
And then she briefly testified at the end of her second direct about collecting the spent casing.
Okay. So we'll have to look for that. I'm going to be reading to the jury 4.41. Members of the jury, you've asked the following testimony be read back to you. The court reporter will now read the testimony that you have requested, and I'll insert as each time. If you tell me what you're reading back, I'll just tell them this is the readback of Captain Carter and all that, okay? So how long do you think it'll be before you can do the readback? Absolutely, no problem.
Judge, can we approach for a second?
Sure. Well, this one's easy. They want tape and thumbtacks. There's the tape. Does anybody have thumbtacks? There may be some in my office. I'll check in a minute. All right. Let me go ahead and print this. All right, I'm going to bring the jury in. Let me talk to them about this readback and get more of a schedule with them. So let's get them lined up and bring them in, please. Yes, ma'am. Stay recognized, presence of the jury.
We do, Your Honor.
Defense? All right. I brought you into the courtroom just to talk to you a little bit about the readback testimony. So you all are asking to have read back. This is how I understand the note. You want us to read back Captain Carter's testimony in its entirety about count 2. Karen Livengood's testimony about count 2, and Markeith Loyd's testimony about count 2. Have I got that right? Okay. And by testimony, we mean direct and cross-examination. All right. I've talked to the court reporter. In order to get this assembled, it's going to take us until tomorrow morning to get it done. We're happy to read it back to you. Please don't take this as us not wanting to read this back. It's going to take until tomorrow morning because the testimony is spread out through the transcript and has to be looked at. We need to make sure we're reading all of it to you. You can continue to work on what you're working on now. I do want to tell you all that I know it's been a very long day for you, all right? You can continue deliberating. We want you to deliberate and be comfortable, but as soon as you all start to get tired, you need to let me know and I'll send you back to the hotel, all right? So are we good with this plan that we will read this back to you tomorrow morning? Yes, ma'am. If you all want to talk about it and send me a note about it, do that, okay? So let me know if that's fine or if you have any modifications or questions about this. That's what took me so long to answer you, is we had to figure out where it all was. All right, so why don't you head back to the jury room and let me know if you have anything. All right. Yes, sir.
Because we discussed it briefly at the bench on the issue of a partial readback, I would just cite the court and defense counsel to Avila, A-V-I-L-A, versus State, 781 Southern 2nd, 413, Florida 4th DCA 2001. It indicates the trial court may provide a limited or partial readback of testimony specifically requested by the jury as long as the testimony is not misleading. That was a head note.
All right, thank you, Mr. Williams. All right, so if they're still requesting the readback, it's incumbent on the lawyers. You're going to need to pull up your real-time transcripts and make sure that there's not something else that you want to read that's specific to the request they made. I'm not, they want Carter, Livengood, and Mr. Loyd. That's it. You don't have to do it tonight. You have to do it before we do the readback.
Judge. Yes, sir. As to the issue of the misleading nature of testimony, in this particular case, there was another witness who testified to results from that investigation, and that would be Richard Root. As you recall, Judge, there were 3 projectiles and 1 casing found.
You can't add witnesses to the requested readback by the jury unless that witness materially alters something. So you're going to have to pull the testimony that you say is relevant and let us all see it. Okay. I can't address it without looking at it. Understood. I can't just start reading off witnesses to them. Okay. Understood. Thanks. Okay.
Just hang tight there. I don't really want to.
both. She testified about both scenes in both first and second.
My notes reflect she testified, the first time she took the stand, she testified about that too. And then she was brought back. These are my handwritten notes. She, the state told me she testified again, but she did that first day testify.
You didn't ask her any questions about that, did you?
I'm sorry?
Did you ask her any questions about it when you called her? 'Cause that's the other time she was called.
No.
So it'd just be one to me.
Right. When I called her, I introduced those photographs from the second physical therapy.
Just one.
didn't get your email. Can you check to make sure you have my correct email?
Still waiting.
Let's see. Okay, so wait, I have another note. All right, this is what I'm getting back from the jury. Monica Pridgeon, count 1. Sergeant Pete Caddis, count 1. Shane Overfield, count 1. Karen Livengood, count 1. Markeith Loyd, count 1. Julia Johnson, count 1. And Dr. Joshua Stephanie. We'd like to retire at 7 p.m. and resume when we have these testimonies in order to come to a verdict, unless we're able to get them sooner. It's 20 minutes to go, so I'll give you all a moment to absorb this. And discuss it among yourselves. Monica Pridgeon, Sergeant Pete Caddis, I'm just reading what they wrote. Shane Overfield, Karen Livengood, Markeith Loyd, Julia Johnson, Dr. Joshua Stephanie. Y'all let me know when you're ready to address this. Judge Wilson's here? Where? Oh, okay. State, you ready?
We are, Your Honor.
All right, what's your position on this?
Our position in order of witnesses is that it would have to be all of the direct and cross-examination of Ms. Pridgeon, all of the direct and cross-examination of Detective Overfield, all of Ms. Johnson's testimony, direct and cross,
Correct.
all of Dr. Stephanie's testimony, direct and cross. The three that are a little more complicated are Detectives Cadis, CST Live and Good, and the defendant. I mean, we're getting into an area where what does related to mean? There's an argument that almost all of their testimonies would be related to count one. I guess we're sort of looking for guidance on those, but the ones I announced to the court, we agree they have to all be read based upon the request from the jury.
All right. So you're saying the issue you have is with Mr. Loyd and what part of his testimony would relate?
Yes, Your Honor.
Okay. And just determining what part of that testimony is related to count one?
Yes, Your Honor.
Okay.
Same with Sergeant Cadis or Detective Cadis.
All right.
And then the same thing with Ms. Livengood.
Yep. All right. Mr. Lenneman?
Yeah, I'm in agreement mostly with what Mr. Williams says. I think the issue about the perimeters of Mr. Loyd is that we have both the heat of passion and the insanity defense and the self-defense all in his testimony. And there are some aspects of the insanity defense that are not present when he talks about specifically Walmart, the state of mind and so forth, the events that occurred with the press, and him believing the police are going to kill him. In terms of Detective Cadiz, again, I don't have that in front of me, but I think what's relevant here is that the defense has said there has been a conflict in the investigation. He's involved with making statements to Mr. Loyd. He's involved with the casing or the projectile that was found by Detective Overfield. And so I don't know what else the perimeters of his testimony is, but unless we hear differently from the jury, I think we have to read all of it back.
I'm not in agreement that we have to read all of Mr. Loyd's testimony back, because all of the stuff about Sade Dixon and all that.
I agree with you on
is
that,
not
Judge.
Part of, so I can tell you right now, I'm not reading the whole thing back.
I agree with you. I think a starting place may be when he talks about the news.
I think what I'm going to do is read the jury this instruction on this one, which is, again, it's 4.4, but it's paragraph 2. I mean, I don't have to read back testimony. It's in the discretion of the court. I'm inclined to read back testimony when asked.
Yes,
but
ma'am.
This is a major chunk of the trial. We would spend about 8 hours reading back testimony with this. So members of the jury, I've discussed with the attorneys your request to have certain testimony read back to you. It will take approximately, I'm going to guess, based on how long all these folks were on the stand, that we're talking 4 or 5 hours of reading here. So that's what I'm going to tell them. To have the court reporter prepare and read back the requested testimony. I now direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you should write down as specific a description as possible of the part of the witness's testimony that you want to hear again. Make your request for reading back testimony as specific as possible. Because this is in essence an entire day of reading back.
I understand, Judge, but my position is, I understand about Mr. Loyd's testimony being narrowed down to the precise issues, and I think we can do that. But I think Ms. Pridgen, and I'm in agreement with Mr. Williams on that, Ms. Pridgen and Julia Johnson have to be read in whole. Overfield's testimony is pretty short. I don't know what they're looking for. But
I don't disagree with you.
Right.
I can't, though, start nitpicking which one of these I want them to be specific about, because then it looks like I'm reluctant to read a certain person's testimony back.
Well, this is my position, Judge. I do not want a reference to me as an attorney, as one of the attorneys have talked about this, because I think that infers that I'm in part of putting pressure on them to narrow their decision and get on with their verdict, and that's not what I want to do. I don't have a problem with the rest of your statement that says, you know, it's going to take 4 hours, go talk about it. I don't have a problem with that. I just don't want to be part of the lead-in.
That's a standard jury instruction. It says the attorneys. I can insert the word all of the attorneys. But, I mean, this is the standard jury instruction. I can tell you that I've been involved in more readbacks than I care to be involved in. And if you have to be careful when reading these instructions to not, you have to read the instruction. State.
We don't object to Your Honor's proposed reading of the instruction. I would just ask the court to put the number of the instruction on the record.
It's 4.4, paragraph 2.
Thank you, Your Honor. But we don't have an objection to the court's proposal.
Yeah, I did. I thought I put that on the record. Can you all not hear me? That's why I'm asking.
You may have, and I missed it, Judge. I'm sorry.
Yeah, it's okay. I just want to make sure you could hear me. So let me take the mask off. What? Can they eat dinner at the, well, yeah, we need to get going because they need to eat dinner. So I need them to narrow this down. This is just way too much readback. And I suspect they're looking for specific issues. So I'm going to bring them in here and read this instruction to them and send them back in there and tell them that we are going to send them home, or home. We're going to send them to the hotel at 7 o'clock. So let's get them in here.
Judge, just for the record, I understand that that's a standard. I just object to the all attorneys.
Well, I'm just going to read it the way it is. I've discussed with the attorneys your request to have certain testimony. I don't think that singles you out. It says the attorneys. I have 2 here and 2, well, 1 over here. Mr. Marrero has disappeared. So, all right, let's bring the jury back in
So
here,
actually,
sir.
just so we're clear, I'm objecting to the.
I've got it. You object to me reading the word attorneys.
No, I'm actually objecting now to this being read.
Okay, I've
Okay,
got it.
Thank you.
State recognized presence of the jury.
Yes, Your Honor.
Defense? Yes. All right, good evening, folks. So I've got your list of all the witnesses. I take it this is in addition to Captain Carter and the others. All right. So I have an instruction to read to you all. And I know you want to go home soon. Just going to need to read this, send you back to the jury room for a minute, and then we'll send you back to the hotel because it is almost 7 o'clock. Members of the jury, I have discussed with the attorneys your request to have certain testimony read back to you. It will take approximately, between both requests, somewhere between 4 to 6 hours to prepare and read back the requested testimony. I'm now going to direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you should write down as specific a description as possible of the part of the witness's testimony that you want to hear again. Make your request for reading back testimony as specific as possible. So if there's some specific issue you're focusing on, that kind of thing, let us know as specifically as possible, because this is 4 to 6 hours of reading. Okay? So last time I'm sending you back to the jury room. Send me one more note. All right, thanks. Okay, so the jury has narrowed their request. Count 2, Captain Carter, position of the car in the parking lot, how he was positioned, how the car was positioned, exact interaction / encounter between Loyd and Captain Carter. And then it says, same with Markeith's account on what happened. Count 1, Monica Pridgeon, exactly what she saw and where she was positioned when the shooting happened. Julia Johnson, that she believed Officer Clayton fired first from when she went to the garden center, her timeline. Count 1. And then count 1, Dr. Joshua Stephanie, which shot disabled Lieutenant Clayton from moving. And then Pete Caddis, trajectory path of Lieutenant Clayton. Y'all want to look at this? This is what it says. So they have narrowed the request down. So I'm going to bring them in, send them back to the hotel. Court reporter, obviously, you're going to need this to figure out what the portions of the testimony are. So I'm going to put this, let's bring them back in, and then y'all can look at the notes afterwards. So I can send them back to the hotel and instruct them for the night. What? Oh, yeah. Yeah. Is she telling them to bring the verdict forms into the courtroom with her? Because they have to get the what? Okay. All right, thanks. State recognized presence of the jury.
We do, Your Honor.
Defense? All right, folks, that was very helpful. Thank you very much. So we'll narrow it down. We'll start the readback tomorrow morning at 9:30. I'm going to send you guys to the hotel since you told me you wanted to quit now, and it's been a very long day for you. So here are the rules. You cannot discuss this case among yourselves unless you're in that jury room. So when you go back to the hotel, on the ride to the hotel, you can't talk about it. All right, take a break from it anyway, folks. All right, clear your heads. So you cannot resume discussions until you're back in that jury room. I'm going to give you this manila envelope. I'm going to give the deputies this. You hand it to the foreperson. If you have done any work, I don't want to know, don't indicate in any way, shape, or form. If you have done any work on any count that involves a verdict form, you are to place it in here, seal it, and have the foreman sign across, the foreperson sign across the seal, all right? If you haven't done anything with the verdict forms, then you don't need to do that. But if there's any verdict form that's been marked, it needs to go in here, sealed, foreperson to sign across the seal. It will be opened by the foreperson tomorrow morning, all right? Because we will gather up all of the evidence and gather up this sealed envelope if it's sealed, all right? Yeah, you can actually put them all in there if you want. But like I said, if any of them are filled out, sign that, seal that manila envelope. Any questions? Everybody know what you're doing? All right, I'll get a good night's sleep, have a good dinner. I'll see you all tomorrow morning at 9:30. Thank you. All right, the narrowing is up here. Y'all need to take a look at it. Court reporter's going to have to take a look at it also to make sure we get this straightened out. They need to be here at 9:30. You all need to be here at 9 so we can talk about this, make sure we're straightened out on what's being read to them. What does this do to your schedule for tomorrow?
Destroys it.
Well, let's talk about that in a minute. All right, anything else we need to talk about this?
Well, yeah, only that I'm reading through Ruth's testimony. and I see him identifying one casing from Carter's. I was under the impression that a projectile was introduced as well from Carter's, but I don't see it in there. If I'm mistaken, correct me if I'm wrong, but I received to get introduced the projectile, one projectile that was tested for its testimony. It's very narrow.
State,
If by introduce, we mean have the testimony read back to the jurors, we would object because it's not been requested.
this is a specific request for readback, and they have not requested it. The court has, at this point, no grounds to read something back that the jurors have not requested, and it would place undue emphasis on that testimony if I suddenly, on my own, started reading it back. But it's late, folks. We're going to recess for the night, and I'll see you all at 9 o'clock tomorrow morning. We'll go over anything we need to before the readback. All right, court's in recess.